everybody. Welcome back. Welcome back. We're going to finally get that motion to dismiss heard today. We're going to get a lot of deep sighs and Mr. Jackson's because we know he's going to be arguing the motion. Now, we're scheduled to start at 11 Eastern, 8 Pacific, which is about 15 minutes from now. However, I suspect we're going to be running a little bit late today, and the reason why is because they are over in federal court this morning. They are having the argument on the habeas petition. And so I found an account that is live tweeting what's going on in the federal court. So we will be able to take a look at that. But before we do that, another thing I wanted to go ahead and share because I was able to hunt it down. The other motion that is on the table today, there's 3 of them on the table. We've got the motion to dismiss. We've got the motion to basically reconsider Judge Cannone's decision that the Commonwealth didn't need to produce the metadata that's associated with all of these sallyport videos that have been coming forth in dribs and drabs in the past year or so. And then the final motion was one I wasn't aware of, hadn't heard of. It's another motion that the defense has filed to exclude a Commonwealth expert on the grounds, Daubert-Lanigan grounds, basically arguing either the witness isn't qualified for this opinion or the methodology isn't a sound scientific methodology. So I was able to find that as well. So what I think I'm going to do is go ahead and share that. This is about as big as I can make it because we're on Twitter here. So hopefully it's going to be readable for you guys. But I'm just going to go ahead and go through it because, boy, this is a little fun, and it's really giving us some clues about where the Commonwealth is going to go in round number 2 of this trial. So this is a motion to exclude the purported expert testimony of the Commonwealth's proffered witness, Dr. Isaac L. Wolf, and request for Daubert-Lanigan hearing. Comes now the defendant, Karen Reed, and respectfully moves this honorable court to include the entirety of the proffered and purported expert testimony of Isaac L. Wolf concerning, what's it about? It's concerning the medical cause and manner of death of the decedent, John O'Keefe, the decedent, the mechanisms of injury, and the conditions of the ground due to weather conditions. They want to bring in a doctor to testify to the conditions of the ground due to the weather. The heart is a rock. The heart is a rock. They want a doctor to say that as well. Oh man, it gets more and more through the looking glass, doesn't it? The more this case goes on. Well, what is this telling us? It's a big tell right here. We obviously know the Commonwealth is shifting its theory of how John O'Keefe died, how this accident allegedly took place, because they didn't really have an explanation last time for why does John have all these skull fractures on the back of his head and a massive 2-inch laceration. So they gave us a lot of possibilities. Well, maybe he might have hit the curb. Maybe he might have hit the fire hydrant. But the problem was these are all, pretty far from where he came to rest. It would have required some just strange motions for that to take place. And there's no blood on any of these items. There's no transfer blood or anything like that. Which, if you crack your head and your skull, skull is fractured and your scalp is lacerated, there's going to be blood at that point of impact. So they didn't have an explanation for any of that. And so now we know in trial number 2, they're going to give us an explanation. And their explanation is going to be that the front lawn of 34 Fairview, where the snow was just barely starting to stick. Remember, we've seen it on video. We heard all the testimony from the Commonwealth's own witnesses about the snow and the patterns and so forth that night when all this was supposed to have occurred. that lawn is what fractured John O'Keefe's skull. That's going to be the Commonwealth's theory. And so I think it's probably pretty clear why they are flailing to come up with some sort of support for that, and need folks for whom it's pretty far outside of their area of expertise to provide that kind of foundational issue of the ground being hard as a rock. You know, it's easy if you could get somebody qualified who would be willing to say that, you would just do that. And so when you can't get somebody qualified to say it, it kind of tends to imply that it's because it's bullshit. But this is going to be part two of one of the gaslighting trials of the 21st century. You know, Delphi was certainly one. We'll give it a run for its money. But the Karen Read trial, certainly the first time around, absolutely rife with gaslighting. And now it looks like we're going to get more of the same. We're going to get, you know, disbelieve your own eyes when you see the video of the snowfall, the cars driving. You know, we saw Karen Read's car driving. You see it outside of the waterfall, the video outside of the waterfall, the testimony from the Commonwealth's own witnesses about what were the conditions. Well, it was, you know, just barely starting to snow, just barely starting to stick. And then you're going to have to, you know, put all that aside because you need to believe the Commonwealth that the ground is hard as a rock. If the ground was frozen and hard as a rock, the snow landing on it, it would already stick. It wouldn't melt. It would stick because the ground is frozen. It melts because the ground is warmer than frozen. Takes a while for the ground to get that cold. And we're also going to have to disbelieve our own common sense. You know, disbelieve your own common sense about weather, injuries, accidents, lawns, you know, our own experience with, you know, falling down on the grass from time to time. Yikes. And the one thing I'll give the Commonwealth credit for, the one thing I'll give them credit for with this shift in their theory here is that it is clear, it seems to me, that they at least recognize that they need to try to come up with some type of theory that is at least a little bit closer to reality. Because it does seem like a pretty reasonable explanation for this skull injury and this laceration, that somebody fell backwards and cracked their head. Watch some boxing, guys. Watch some boxing. Watch it, and somebody takes a knockout shot. Pooh, lands right there, right at that occipital point on the back of your skull, cracks that thing right into the ground. Yeah, that seems like a pretty reasonable explanation to me. That always has. And you know, part of the problem, I think, for the Commonwealth is how consistent that is with, oh, you know, you get in a fight, especially on something like a hard surface. A lot of street fight videos out there, you know, people doing dumb shit on like asphalt and concrete and stuff like that. It's a terrible idea. Don't do it, because you get knocked down and you crack your skull against a hard surface like that. It can go really bad. It can go really bad for you. So yeah, that seems like a pretty plausible mechanism of how this injury took place. The problem is of course, you know, ground, lawn, probably not going to cut it. Probably not going to be hard enough to fracture somebody's skull. And it doesn't take a scientist to be able to tell us that. That's a common sense thing that we can all apply, because the ground, you know, for the most part, especially if grass is growing on it, is not a rock. It's not a rock. It is in fact soil, and you know, soil tends to not be hard as a rock. So that's where they're going. We see where they're going. They're trying to come up with something that is a little bit closer to reality than, well, he pirouetted, through the air and cracked his head against the fire hydrant, and then, ended up lying down on top of his phone six or so feet away. Just not a credible explanation. So they're trying to get closer to reality, but they're having a hard time finding actually qualified people to provide them with those foundational facts that they need to be able to establish that theory. So enter Dr. Wolf. Exclusion of the proffered testimony is compelled because it fails each of the two main prongs of the Daubert-Lanigan inquiry, qualifications and methodology. That is, Dr. Wolf is not qualified to render the opinions he proffers. It is undisputed that he is not a pathologist, nor is he qualified to scientifically measure the material properties of the ground outside of 34 Fairview Road. Yet the Commonwealth is seeking to elicit testimony from Dr. Wolf about the decedent's cause of death, the mechanism of injury, and the conditions of the ground due to the weather conditions. He thus fails, per se, the crucial qualifications inquiry of the Daubert-Lanigan standard. This failure is not curable. Yeah, if you don't have the qualifications to give the opinion, unless he gets his PhD in geology like this week, he's not going to be qualified to give this opinion. As a neurosurgeon, he's a neurosurgeon. See, when I heard this in court yesterday, you remember, I told you I assume, and one of these days I'll learn not to assume good faith and reasonable argumentation on the part of the Commonwealth. I assumed it would be talking about the nature of the injury, the brain injury, and what kind of effect that would have maybe on somebody's presentation, somebody's capacities, its lethality, stuff like that, seems pretty well within the purview of a brain surgeon. But no, they're not even asking that. They want him to say the heart is a rock ground. Caused this skull fracture to the back of his head. As a neurosurgeon, Dr. Wolf lacks the requisite background, training, and experience necessary to interpret an autopsy report because he is not a qualified or board-certified forensic pathologist. Thus, his expertise is limited to treating injuries rather than determining the circumstances under which particular injuries occur. This is an interesting argument. I don't know if this is accurate or not. I do notice that throughout this memorandum, there's not an affidavit. Like, you could get an affidavit from somebody like Dr. Russell, who is a pathologist, and kind of explain what the different limitations are between clinical practice and pathology practice. It seems like a reasonable argument to me, but I really don't know. And it seems also like there's likely to be a little bit of overlap. One of the situations that would come up in my mind is in, for example, like in the ER, a doctor is going to be dealing with, say a child with a black eye. And doctors are mandatory reporters. They have to report situations where they suspect there is something like domestic violence, child abuse. Obviously, the details vary by state law. This is very common that doctors are in a position to have to make these kind of reports. And so, is that kind of related to ascertaining the cause of an injury, determining the cause of an injury? I'm pretty sure the standard is not just, unless the child says, "Daddy hit me in the eye," or whatever, that you have to report it. If the child says, "You hit me down, I fell down the stairs," but the child, is pretty obviously being abused, pretty sure the doctor is still going to have to report that. And that's going to go directly to the doctor's ability to kind of ascertain that cause of injury. So I am interested in this argument, and I think it's compelling. I think it's good, but I'm just not 100% certain that it's fully substantiated as much as maybe it needs to be. So they'll have the opportunity. Well, maybe they won't have the opportunity to do a reply at this point, honestly. because, we're hearing this right now. So it's not like we're going to be able to see what the Commonwealth responds to and then maybe go and get an affidavit from Dr. Russell or something like that. We're going to be dealing with this on the fly today. I don't think the Commonwealth has even filed a response. So that's just one. That's kind of part of the limitation I see of this particular challenge, is just that distinction doesn't seem to be substantiated with any kind of citation that they've made. But it actually does a little bit further go into some of that. Just not sure it's quite as crystal clear as the defense is arguing and certainly wants it to be. So he says Dr. Wolf is not qualified to testify regarding cause and manner of injury. This type of opinion is something reserved for a forensic pathologist. In addition, the methodology that he invokes in his report is not reliable. Among other defects in his methodology is replete with errors, as is demonstrated by his failure to acknowledge any contributing medical abnormalities of the decedent and his failure to appropriately address and consider the toxicology and autopsy reports. The failure of either Daubert-Lanigan prong requires exclusion of the proffered testimony, and Dr. Wolf fails both prongs. Not sure they're going to get there on the methodology either, because the methodology being replete with errors, this is the same argument that the Commonwealth was trying to make to exclude Dr. Russell, and it essentially amounts to an argument that the expert is wrong. But that's not what Daubert-Lanigan is for. Daubert-Lanigan is just about the basic foundation of are they qualified to give an expert opinion? Is this opinion in fact an expert opinion? So even if he's wrong, he's allowed to testify. The remedy for that is to put on your own expert to explain why this expert is wrong. Same type of argument that came up with, the cell phone guy, drawing a blank on his name, Richard Green. The challenge to Richard Green was basically you should throw him out because he's wrong. That's not what Daubert-Lanigan is about. So I do really think this motion is going to come down to, can they establish a real clear division of expertise between the forensic pathologist and the clinical, treating neurosurgeon, and then methodology. Can they challenge the methodology that he used as being improper under the standards that either a forensic pathologist or just whoever has the expertise to be able to make these kinds of determinations would ordinarily use? So the argument, the Commonwealth fails to and cannot meet its burden to establish the requisite qualifications of Dr. Wolf to testify regarding the cause and manner of death or mechanism of injury. So the crucial inquiry in Massachusetts for a Daubert-Lanigan hearing is whether the proffered witness is qualified to testify regarding the subject matter of his testimony. Yes, not qualified in general to testify about something, but the actual subject matter of what he's being offered for. The subject matter of the proffered testimony of Dr. Wolf and his accompanying report, Dr. Wolf report or report, is the medical cause of the injuries and wounds to the head of the decedent as well as the cause of death. Although Dr. Wolf is a trained neurosurgeon, the Commonwealth has failed to prove that Dr. Wolf has a reliable basis in the knowledge and experience of his discipline to render an opinion in the field of determining manner and cause of death, identify pattern injuries, diagnose post-mortem hypothermia, and properly read and interpret an autopsy report, all of which require the expertise of a board-certified forensic pathologist. Now, there is a citation there, id, and I'm assuming id, I don't know what id is referring to. Is that going back to Commonwealth versus Rentala? Is it going back to his own report? But they are citing something for that. It's just not clear what exactly they're citing. As a neurologist and clinician, Dr. Wolf's background, training, and experience is limited to treatment. He is not a board-certified forensic pathologist and has no training or experience in determining mechanisms of injury or the cause and manner of death. The crucial issue in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. Dr. Wolf's experience and training is limited to providing neurological surgery services, specifically radiosurgery procedures for inoperable brain tumors. That is very specific. It's a very impressive expertise, but it also doesn't seem to be an expertise that has an awful lot to do with this particular case. While Dr. Wolf may be able to provide expertise on how one would treat a brain injury or provide neurological care, he lacks sufficient expertise in conducting the type of post-mortem analysis of the cause of injuries and death included in his report. In his report, Dr. Wolf repeatedly exceeds the scope of his qualifications by reaching opinions on cause of injury, namely, the mechanism of injury was a fall backwards. That doesn't seem that unreasonable to me, but I understand we're talking about qualifications here. The head injury was clearly inconsistent with any type of mechanism of injury, such as a bar or hammer or a car hitting him directly. Oh, that's interesting. So the car didn't hit his head. The frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Ultimately, his death resulted as a combination of the brain injury and his hypothermia. The frozen ground was enough that when he fell back, the injuries were sustained. Yeah, this I don't really have a problem with saying that's probably beyond the scope. That's probably beyond the scope. Just because you're the expert in the brain doesn't mean you're the expert in the frozen ground. That seems like quite a bit of a stretch to me. Here we are now back in projection land, right? It's the gaslighting trial of the 21st century. Wasn't it just yesterday that Mr. Brennan was complaining, making accusations about who's writing which report for the expert? And you want us to believe that the expert spontaneously came up with this theory that the frozen ground caused the injury to the back of his head, and not that that's what conclusion you wanted him to reach? So he put it in the report, and that's why you had to go to a guy who isn't qualified to have that opinion in the first place, because somebody who is qualified to have that opinion wouldn't support it. Yeah. Here, Dr. Wolf has no experience in diagnosing hypothermia from a dead body, no experience in identifying pattern injuries. This is going to, like, could it be a bar or a hammer or something like that? And is not trained to read and interpret an autopsy report. In fact, by law, a neurologist is not qualified to issue a death certificate declaring the cause or manner of death of someone who dies of unnatural causes. He is not a forensic pathologist and lacks the appropriate licensing requirements and training to do this properly. Okay, so he can't issue a death certificate. But I'm just still not finding that persuasive that by virtue of being a medical doctor, a neurologist, somebody who studies brains, that he isn't therefore qualified to opine about brain injuries and causes of brain injuries. I'm just not quite there yet. A jury should not be permitted to consider such speculative evidence, and Daubert-Lanigan requires that this court ensure that Dr. Wolf's conclusions have a reliable factual basis and are limited only to matters precisely within his field of expertise. A forensic pathologist is a physician who has undergone at least 3 years of anatomic pathology residency, then completed 1 year of subspecialty training, and may have additional training and expertise within their subspecialties. Okay, so now we have this article from this journal, Missouri Medicine, Death Investigations in the United States. Great. Dr. Wolf has not completed a residency program in anatomical and clinical pathology or any fellowship program in a subspecialty of pathology. He has not received training in other disciplines within the forensic sciences, such as toxicology, and he is not board certified by the American Board of Pathology nor the Osteopathic Board of Pathology. Dr. Wolf ventures well beyond his qualifications as a neurologist and attempts to step into the role of a pathologist and pedologist to opine that the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained, or that his death resulted as a combination of the brain injury and his hypothermia. Dr. Wolf is not qualified to testify as to the cause of death, manner of death, mechanism of injury, or the qualities or properties of the ground outside of 34 Fairview Road on the night in question. We haven't established that. All we've established is what the basic training is for a forensic pathologist, but we haven't established still that only the forensic pathologist is the one that's qualified to be able to make this type of determination. You know, something I think that's really important to bear in mind when you're talking about experts, yes, education, credentials, that type of thing certainly matters. Training matters, but experience also matters. And so a guy who studies brains, treats brains, I will grant if his particular unique specialty that like he's focused on his whole career has been brain tumors, then he probably hasn't encountered a lot of brain injury. But I don't know. I don't know what that would look like in a residency type of program. I don't know, how broad your exposure would be to brain medicine kind of in general, before you end up in this narrow kind of subspecialty of certain types of brain tumors. So I don't know. I'm not confident that the defense has really made this link that is a necessary limitation on the qualifications of a clinician. The court need not reach the other prong methodology of the Daubert-Lanigan inquiry to exclude Dr. Wolf because the failure on the qualifications prong alone warrants exclusion of his testimony as to mechanism of injury and cause and manner of death. Even if this court proceeds, and now I got to go to the other tweet, to the methodology prong of the Daubert-Lanigan inquiry, the proposed testimony of Dr. Wolf fails on this prong as well. So now the Commonwealth fails to meet its burden that the methodology of Dr. Wolf is reliable. Even if he's qualified, if he's not following a reliable methodology, it still doesn't come in under Daubert-Lanigan. So let's see. In addition to whether Dr. Wolf is qualified, this court must also determine that the expert's testimony is sufficiently reliable to reach the jury. As the proponent of the evidence, the Commonwealth must prove by a preponderance of the evidence that Dr. Wolf's methods and processes behind his opinion are scientifically reliable. The proponent of evidence may establish reliability by applying a non-exclusive list of Daubert factors, including whether the scientific theory or process has general acceptance in the relevant scientific community, has been or can be subjected to testing, has been subjected to peer review and publication, has an unacceptably high known or potential rate of error, and is governed by recognized standards. General acceptance in the relevant scientific community is sufficient to establish reliability regardless of other Daubert factors. If the process or theory underlying an expert's opinion lacks reliability, that opinion should not reach the trier of fact. Medical examiners, as expert witnesses, may base their opinions on 1. Facts personally observed, 2. Evidence already in the records, and 3. Facts or data not in evidence that are independently admissible and are a permissible basis for an expert to consider in formulating an opinion. So, they can rely on what they see with their own eyes, what has been introduced in evidence, so the photographs, the circumstances, so forth, and stuff that didn't get introduced but would be admissible and is a permissible. It's something that experts in that field would ordinarily rely on. So, for example, maybe like a toxicology report. We don't admit it into evidence, but it is admissible. It is the type of thing that experts rely on, just hypothetically. Further, a substitute medical examiner who did not perform the initial autopsy may offer an opinion on the cause of death based on his review of the autopsy report prepared by a medical examiner and autopsy photographs, since these are materials that which expert medical examiners are accustomed to rely on in basing their expert opinions. However, Dr. Wolf is not a medical examiner, nor is he accustomed to rely on autopsy reports and photographs to draw conclusions. That might be the case, but it doesn't mean he's not qualified to do that, and we still haven't established that only forensic pathologists are qualified to do that. Dr. Wolf claimed no scientific or technical basis for his opinion. He reviewed various documents and exhibits listed in his report as the basis for his conclusions and offered no explanation of the methodology of his analysis. Moreover, in reaching his opinions and conclusions, he ignored the precise information that must be considered in determining cause and manner of death. Namely, he fails to address or acknowledge the abnormalities present in the decedent and fails to acknowledge any evaluation of the toxicology report, both of which are critical steps that would be considered by anyone trained in forensic pathology in determining cause and mechanism of injury. This is saying he did it wrong. This isn't saying his methodology is bad. This is just saying he did it wrong. And the remedy for that is cross-examination and in presenting your own expert testimony. The format of a forensic pathologist approach differs from a treating physician. A forensic pathologist's investigation begins with death and does not conclude until the results of the autopsy, histology, toxicology, and other ancillary studies have been completed. Now we're going back to that medical journal. As in clinical medicine, no finding or laboratory value is interpreted by a pathologist in a vacuum. Particular findings are interpreted in the context of all available pertinent information. I don't see that he's specifically said he hasn't, necessarily done that. You can point out he's wrong. Further, the section of the death certificate that is most often misunderstood is the other significant conditions section. Here, Dr. Wolf neglected to acknowledge the entirety of this section in his report. Ultimately, the touchstone of admissibility is reliability. This court must limit its analysis to reliability of the methodology suggested, not the perceived persuasiveness of a proposed expert's conclusions, especially one that Dr. Wolf is not qualified to make and is not supported by evidence or scientific reliability. In conclusion, Dr. Wolf is not a pathologist or a forensic pathologist, and his proffered testimony and methodology is outside the scope of his expertise, thus failing both prongs of the Daubert-Lanigan standard. For this reason, Ms. Reed respectfully requests that the court exclude Dr. Wolf's proposed testimony because the Commonwealth failed to and is unable to satisfy the burden of establishing the proposed testimony meets the requirements set forth in Daubert versus Merrill Dow and Commonwealth versus Lanigan. So that's going to be the motion today. I don't think they're going to get this one. I really don't. I don't think there's any problem with limiting the doctor from being able to testify as a matter of fact that the frozen ground was hard as a rock. But the Commonwealth's already established they're going to rely on lay witnesses to tell us that. They're gonna go ahead and let the police officers and the people who were out there at the time, probably, just putting this out there, maybe the same people who were testifying in the last trial that the snow was only just starting to stick to the ground, they're now going to be testifying that, oh yes, the ground was absolutely hard as a rock. So they'll get that precursor fact, that foundational fact into evidence through other witnesses. And then if it's in evidence, it's something that the expert can rely on in formulating their opinion. So I don't think there's a problem with him not being able to say, in my opinion, the ground was hard as a rock. But I don't think they're going to give it. I don't think they're going to give this one to the defense as far as his qualifications and as far as his methodology. It's a little close to, from my perspective, like Dr. Russell. A substantial amount of Dr. Russell's expertise isn't because she took classes or got a specific degree or something like that. It's because she saw lots and lots and lots of dog bites. She saw and treated and evaluated and examined and, she's got a massive amount of experience with dog bites. So if this guy's got good experience with head injuries, I think they're going to let it go. I think they're going to let it go because I recognize there's a distinction. Dr. Russell is a forensic pathologist, but I don't see where they've given us a basis to conclude. They've asserted that that's the dividing line between the forensic pathologist and the clinician, but they haven't substantiated that with anything beyond their own assertion. They haven't, brought a medical journal. They haven't brought an affidavit, nothing like that. So I think that's going to be the defect, I guess, for lack of a better way to put it, in this motion. It's going to give Judge Bev an opening to say, if he's a doctor, he's seen a lot of injuries. You know, he's an expert in the brain and how the brain works and how brain injuries can happen. I think they're going to let it go. So that's my prediction on the motion, but glad that we got to see it and what that is all about. So I'm hearing that we may be done in federal court. I have here this live stream or this live tweet that we can go through to kind of see what happens. This is from Boston Justice. Until the court comes on, I'll just go ahead and kind of take a look at what's been happening in federal court this morning. And once they come on, we'll jump over to that and then maybe come back to this during one of the breaks. So Reed's attorney, Marty Weinberg, opens, I believe strongly the court should establish a precedent that a right to post-trial voir dire is an essential part of the double jeopardy protections. In essence, the state court should have investigated the jury's findings, he says. Judge Saylor asks Weinberg to explain what would give him the power to probe what happened in that jury room. Weinberg cites constitutional grounds. I wish we knew which constitutional grounds. I mean, I assume we're talking about double jeopardy. Fifth Amendment, but I don't know. I don't know which constitutional grounds. I do notice here, I believe strongly the court should establish a precedent that a right to post-trial voir dire is an essential part of the double jeopardy protections. He's arguing for an extension of the law. This is kind of a little bit related to what I was talking about yesterday, where sometimes you got to just recognize that the law is really not on your side. And that's not a dead end. Oh my Lord, as a defense attorney, like it's not even close to a dead end. Because it's just your invitation to come up with reasons for why the law needs to change, or why there's a gap here that needs to be filled, or why this is inconsistent with other types of precedent in similar areas. This is where you get into some kind of high-level policy-based lawyer stuff, which is really what reviewing courts and reviewing processes are really all about. So notice that right off the bat, the court should establish a precedent that there's a right to this type of... What he's acknowledging through that is that there isn't currently a right. So the court needs to make one because without one, you don't have sufficient protection for double jeopardy. The acquittal is not the announcement. It is not the finality of the verdict. It is the decision by the jury, Reed's attorney Weinberg tells the federal court. This is important, and this is also a little bit related to what I was getting at yesterday, where the big concern I have with the way that the way that the legal analysis is structured is just, well, if you have a verdict under state law, then double jeopardy applies. But if you don't have a verdict under state law, then there's no double jeopardy. And this is very concerning because then it means the scope of your protection under the double jeopardy clause depends on the whim of the legislature and what they decide to define as a final verdict or not. So, you know, the legislature goes in and decides, well, any verdict of not guilty is not a verdict. It's not final. I mean, I'm using an extreme example just, you know, for purposes of illustration. Of course, the legislature is not gonna adopt that. But there's nothing that says they couldn't. There's no limitation on the power of the state to be able to define its own processes like that in its own courts. And so that's kind of the point here, is that under the structure of this analysis, the way it's been adopted so far, the federal court would have to just defer to that and say, well, under state law, there's no verdict. So, you know, they voted not guilty. That's not a verdict under Massachusetts state law. So she can be retried. And that's clearly inconsistent with the entire common law tradition that we have of trials and jury trials and processes and so forth. So the common law does matter in this type of context. Here we have powerful evidence that the jury acquitted, and the state's decision is, so what? Who cares? Weinberg says. He notes none of the other 7 jurors have voiced any opposition, even anonymously, to the claim of the 5 that the jury acquitted on 2 counts. It's true. This got a lot of publicity. There was a lot of opportunity to, you know, speak up and say, no, that's wrong, to contradict it, and nobody did so. That's the one we just saw. Weinberg urges the federal judge to call the Karen Reed jurors into his courtroom in Boston, where there are no cameras, and question them. Is there precedent for a federal court to require voir dire of a state court? The judge asks. There is none for a double jeopardy contention, Weinberg says. Yeah, there's no precedent for what he's asking the court to do. He's just essentially trying to make an argument that this is the right thing to do and this is the fair thing to do, and that's why you should find a legal pathway to be able to do this. So the fact that there's no precedent for something doesn't at all mean that it's not legal. Every single case of first impression that comes up in a reviewing court is a case without precedent by definition. Pretty much, the overwhelming majority of the stuff that goes up into the Supreme Court, it's a case that doesn't have any precedent. So it doesn't mean that the Supreme Court automatically reverses everything because there's no law on this. We have nothing to guide us. No, your job is to then interpret the situation, analyze the situation in light of the existing precedent. Let's see. Reed attorneys Alan Jackson and David Yannetti are sitting in the back bench today in federal court. Reed's other attorneys are sitting in the gallery across from her parents. There are empty benches and only a handful of spectators. Many Reed supporters decided to stay away in deference to the serious, tightly constrained culture of federal court proceedings. I think that was prudent. I think I've mentioned before, I have quite a bit of ambivalence about the idea of protesting court proceedings in the first place. And the main reason why is just because, from my perspective, the point of a protest, it's to be persuasive. It's to apply pressure. It's a very political action. And so it's directed at people who have the power to make a decision that will change policy, change the law, something like that. I really don't necessarily like the idea of that type of pressure being applied to jurors, being applied to courts. It's supposed to be apolitical. We can definitely argue about all day about whether or not it in fact is. I'm not naive. I recognize there's a lot of those types of considerations always at play, but it's just not consistent with the structure of how the process is supposed to work. So that's, I think, even more the case, like they're pointing out culturally in the federal court. The state courts can be known as maybe a little bit rowdy, a little bit, rough them up. But the federal courts are not. So I think this was probably a smart move to not make a lot of noise at the federal courthouse. Nothing prevents Judge Saylor from doing some fact-finding, Weinberg contends. There's nothing more important than the double jeopardy clause. This case cries out for some decision-making in an area that hasn't had a great deal of decisions. He's true. This is an area that hasn't had a lot of decisions. The federal court on habeas does have the power to have an evidentiary hearing, to take evidence and to make factual findings. It's not definitely not something that's unheard of. So he is right about all that. Judge Saylor has some factual questions. He wants to know how much fact-finding the SJC did and whether he's required to give deference to their findings. Weinberg describes some of the facts on record that led to SJC declaring Judge Cannone had manifest necessity to declare mistrial. Defense disagrees, contends judge deviated from her prior practice by not talking to defense or prosecutor before declaring mistrial, argues she did not seek any alternatives to mistrial. She could have asked the jury if there was a unanimous decision on any of the counts, Weinberg says. So what this is getting at is the part of the Supreme Court decision, the Massachusetts Supreme Court decision, where they talked about, they went through the process. We already had, the two conferences requesting the Tui Rodriguez instruction. The defense had requested the Tui Rodriguez instruction. Defense had... So based on that, defense is kind of like putting the prospect of the mistrial on the table. The defense had objected, throughout the proceedings. They were no shrinking violets. I remember Judge Bev made that finding, and that they basically had an opportunity to be able to contest it from the point that the judge said they're at an impasse. They could have, they could have said something when she tells the jury, I'm declaring a mistrial. They could have objected when the jury is leaving the courtroom. They could have said, Your Honor, we'd like you to maybe follow up on this a little bit more. That part of the decision of the Supreme Court that's based on just the facts of what happened. That is typically something, that the court has to give, the federal court has to give deference to the state court on. And so that's what the Commonwealth leaned on in their argument here. It was a big part of their objection is that you don't have the authority to redecide the facts that were already accepted by the Supreme Court. And so once you accept those facts from the Supreme Court, you're inevitably left with the decision that the Supreme Court reached. So that's the argument. Can you reach a conclusion of manifest necessity based on the facts that the Supreme Court found? Is that the necessary conclusion that you have to reach? Is it possible to reach the alternate conclusion that even in spite of all these facts, there wasn't a manifest necessity? That's where the room is for the defense to maneuver here. Does that argument require I ignore what happened with the first and second notes? Judge asks. Weinberg responds, the dialogue surrounding those notes shows defense wanted a verdict, not a mistrial, that the judge's prior practice was to read the jury notes to counsel before the public. She deviated from that process at the last minute and declared game over. I think this is a pretty good argument. Now, the defense wanted a verdict, not a mistrial. That's good. It's a good argument. But I'm not, necessarily buying it. I'm not necessarily buying that they wanted a verdict, not a mistrial, because if you want a verdict, you let them keep going. You let them keep going. You don't push for the dynamite, get it done or go home. So, I mean, I'm skeptical. Now, of course, they'd already been informed. Jury's saying we can't reach a verdict. We can't make a decision. We can't come together. Is the Tui Rodriguez designed to make them reach a verdict? No, I mean, that's the whole point. That's the whole point of it, is it's supposed to be non-coercive. It's supposed to remind them that if you possibly can, you should. But if you can't, it happens, and you're not to sacrifice your conscience, your deeply established principles and stuff like that just for purposes of reaching a verdict. So the Tui Rodriguez instruction isn't to try to get a verdict, it's just to determine whether we're really sure that the jury can't make any more progress. But I think this is an excellent point that, the judge did start this habit of reading the note to the counsel, asking for their feedback, and then with this final note, she didn't do any of that. She operated as though there was only one path forward at this point, when in fact the defense has pointed out, I think pretty persuasively in their briefing, that there's multiple pathways. Okay, just because the Tui Rodriguez instruction means you can't send the jury back without their consent, well, they can consent. They can consent to do more deliberation. So you could ask them about that. It's just one of the kind of examples of how there was some kind of alternate. This wasn't a one-way street that she had to go down. And then just obviously the whole issue of inquiring, verifying, is this all of the counts? Is this everything that you considered? You can't reach agreement on anything, just to clarify that. That was an option, and it was not followed. Simply put, Superior Court Judge Cannone erred, reads attorney Weinberg, tells the federal court she made a mistake. She misunderstood the notes. If the jurors' post-trial claims are found true, there was no manifest necessity for a mistrial on all counts, Weinberg says. This is a tougher argument for me because, the notes, I gotta agree, the notes don't really give a hint that they're in agreement about anything. The notes certainly imply they can't reach an agreement on anything, but there is a lot of, there is some messiness here with the jury instructions and how it's instructing them to to proceed and whether this is kind of an all or nothing deal. And there's just a little bit of inconsistency in the language throughout the instructions as they were given, as far as what the jury was supposed to do and how they were supposed to proceed with that. So I'm not necessarily sure I agree that she misunderstood the note, but I'm not sure that that's the point. I don't think it matters if she misunderstood the note, even if the jury was saying, you know, even if the note is reasonably communicating, we're not in agreement on anything, that still doesn't mean your only option is just to march him back in and declare a mistrial. The Commonwealth is up, says factual findings were made that require deference and SJC rulings that must control. Those determinations cannot be relitigated in this habeas action. That is unfortunately the truth. That is the standard on habeas. They're stuck with a lot of what the state court does. And that's where this issue of the verdict and what constitutes a verdict, that's the room and the opportunity that I see here, that they have to find a way to get that out of a question of state law and constitutionalize it, because it's so critical to these double jeopardy protections. It can't hinge on the whim of the legislature and how they choose to define it. The Commonwealth strongly rejects Karen Reed's defense argument that Judge Cannone did not consider alternatives to a mistrial, cites her actions in response to the first notes when she encouraged consensus. The state attorney argues no inkling in the juror notes of agreement on any of the charges. Well, again, I'm not sure that matters, because the only option available to her was not mistrial. If nothing else, she can ask the jury, do you consent to go back for more? But she never inquired of the defense if that was something that she should consider. Federal Judge Saylor says he's wrestling with his role, says he must accept SJC interpretation of state law and show deference, not total acceptance, however, to SJC factual findings. He calls it all somewhat fuzzy. The Commonwealth responds saying it's clear the SJC's view must control. The SJC, the Commonwealth, it's fun to see they're arguing in the federal court rather like they argue in the Commonwealth down there in the county court, where you know, the judge is pointing out a sort of reasonable conflict, and now the conflict is the Commonwealth is going to come in and tell you how you should feel and how you're wrong, like why you're wrong to think that way. Yeah, it's not clear. If it was clear, we wouldn't be having this argument up here in federal court. Federal, yes, we just said that. I gotta refresh, I think, because there's going to be some more here. She made a mistake. Commonwealth wrestling with his role. The Commonwealth argues Massachusetts law requires a verdict must be read aloud, I think this is ALOUD, into court or doesn't count. The double jeopardy clause of the U.S. Constitution does not go so far as to say a state cannot impose that requirement, the state's attorney tells the federal court. Well, no, in fact, the double jeopardy clause is silent on it, and that's why it's up to this court. It's up to the federal courts to determine where's the constitutional limit between what the speedy trial, the double jeopardy clause requires, and what states are allowed to do as far as adopting their own criminal procedures. He says juror could change their mind about the other counts right up to the declaration in court. It has happened, the state's attorney says. Well, yes, it can. Yes, it can. It's just that's not the situation we're dealing with. So Reed attorney Marty Weinberg gets to respond to the Commonwealth, says the law doesn't bind the federal court from looking at this record. Weinberg, citing long list of cases, he says supports his argument. State law doesn't govern when state law conflicts with the double jeopardy clause, he says. That's good. That's the key of it. That's the crux of the argument. Judge Saylor says he will issue his opinion as quickly as I can under the circumstances. Mr. Weinberg said it's a wilderness. It's a thick forest anyway, the judge notes. It sounds rather like the Valdivian rainforest. Going through hikes in some of that area, I would often just scratch my head wondering how anybody ever found a way through like the first time. You know, who went through with the machete and figured out like this is the lay of the land, and this is the terrain, and this is the way to go, and where are you, what direction are you even facing? It's a thick forest. It is. This is a messy situation. It is something that is, you know, fairly new, fairly unique. So, yeah, you know, I continue to think this is really a long shot for Karen. You know, she's on the back foot on this one. I don't think there's really any question about it. She is the underdog. But she's made a much stronger showing than I really had anticipated when all this was going through the process at the state level. At the state level, it was very clear to me where this was going to go. Didn't have any problem calling the outcome. But at the federal level, there does seem to be a lot more in her favor, specifically where it comes to this manifest necessity issue. And then just also the opportunity that you have to find that room to maneuver. There's a gap in the law here. Here's where that gap needs to be filled. Here's how you need to fill it, because it's creating an injustice. It's creating a situation that has a potential for abuse. It gives the state far too much control over the scope of a defendant's constitutional rights. And that's typically not going to be what the framers intended to do. Most of the time when you're talking about you know, constitutional sorts of protections like that, it's not really like an originalist argument, but there's a lot of common law. A lot of the common law that existed at the time is kind of what's going to control. And so things like, for example, we had recent Supreme Court cases dealing with less than unanimous juries. You know, there was it was Oregon and Louisiana were the last two states that allowed a criminal defendant to be convicted by a less than unanimous jury. And I'm pretty sure in Oregon it was like 9. They needed 9. I can't remember now off the top of my head. But anyway, so the U.S. Supreme Court took a look at that and said no, based on the common law tradition and the way that jury trials were, you know, conducted at the time of the founding. That's what they would have had in mind when they adopted the right to a jury trial in the Sixth Amendment. So based on that, you have a right to unanimity. And those states that are allowing less than unanimous verdicts, those are falling short of the bare constitutional minimum. So that type of thing is not really uncommon. Not really uncommon. Didn't see anything in the briefing about you know, the common law tradition when it came to mistrials, hung juries, what constitutes a verdict. I mean, you got limited time, and you know, this may not be exactly the forum to do that, but it's just, you know, there's always roads you can go down as a lawyer. Often writing a legal brief is like it's like well, what I hear from my artist friends about painting or drawing or something like that, you're never finished. At some point you just stop. You just have to stop. And legal writing is often the same way, because you can go down a lot of rabbit holes. You can explore a lot of possibilities, but you're limited by time. You're limited by, you know, what your client can afford to pay for. You have to have priorities. Considering the audience you're in front of and the venue that you're in and so forth. So not like criticizing them because they didn't go and read Federalist papers about, you know, about jury trial or whatever. I mean, it wouldn't even be in the Federalist papers, but it would be in like Blackstone and stuff. It would be in old school cases and commentaries and things like that. Well, I mean, they got done, but we're still not getting started here in in Massachusetts, and it says live court will begin around noon, so that's about 15 minutes. Attorneys are on their way. I hope we're not going to like immediately break for lunch. Judge, please have the foresight to have your lunch early, and that way we can get started at noon and we can just go through the hearings and not have to stop for an hour in the middle of it. I see we've had a few comments come in, so I will go ahead and pull those up. We'll look at those. Shards of words, thanks for the coverage. Well, thank you for joining us today. I'm looking forward to things getting started here. Shards of words, iPhone user membership link, please, mods. Yeah, the iPhone membership thing, I don't know why it's a thing. I don't know why they've made that challenging. Is it a YouTube Google thing? I don't know. But hopefully somebody is able to help you out with that and get it taken care of. And there you are as a member. So praise be. Hopefully that has been sorted and that link is now out there. Melissa Dotson, neuro is not pathology. Even a proctologist knows that a neurologist shouldn't butt into their expertise. I totally buy this argument, and especially when it comes to things like scope of practice. I know scope of practice is something very, very important in medicine. You need to stay in your lane. Really important to stay in your lane. And so I'm totally receptive to the possibility that, like, yeah, this is crossing over the lane. My concern here is really with the lawyering, with the legal side of it, because you can't just assert something as the case. You got to have it substantiated, and it needs to be substantiated by some type of source that's persuasive or binding, a binding, court decision that says this is the sole purview of the forensic pathologist. That's perfect. That's ideal. That's the high priority thing if it's out there that you would get. Persuasive, something like that from another jurisdiction, one that isn't necessarily binding on this court, but it's persuasive because another court looked at it and reached that conclusion. Or something, yeah, from like a medical journal or training manual materials. I mean, I don't know, anything like that would be out there that helps to kind of more clearly define where's the dividing line between these practices. Also persuasive, an affidavit from somebody who knows what the difference is. I know we don't necessarily want to keep going back to the Dr. Russell Well. But this really is something she could have done because she is the pathologist. She is an expert in that. And so she would be expected to know, here's where the dividing line is between what a pathologist does and what other areas of practice can do. So I'm not at all taking issue with the fact that there are dividing lines. I'm taking issue with the defense's support for their argument that the dividing line is where, beyond where this opinion is being offered. Alessi's big brain to free Karen Reed. I'm so excited to get more of Alessi's big brain today. I'm especially excited because, we went through this motion and I'm a little bit skeptical of it. And Alessi is much, much smarter than me. So, I expect he's going to understand potentially the shortcomings of what he's asserting. So I'm very interested in seeing how he argues it. I feel like a lot of what I've seen from Mr. Alessi so far has been he's been on the front foot. He hasn't been so much on the back foot. Now, I will say the exception to that was the argument when he was addressing the whole candor to the tribunal stuff, that hearing. And in terms of his presentation, he definitely didn't have the the confidence, the come forward, like you did yesterday with the no. In fact, it's not a Google search. I went to the National Academy of the Sciences head for geology and conferred with him. That very confident, just aggressive almost style. He didn't have that so much in the candor to the tribunal hearing. He was a little bit more just kind of lost his way a couple times, had to kind of re-find it. Still a very strong presentation from my standpoint. Very methodical, very systematic, very organized, has an entire binder. Has a way of walking through the points to reach the conclusion that he's arguing. So he's very, very easy to follow, and he's very persuasive in that respect. So that's like really the closest we've gone to seeing him argue a defensive type of position. And I feel like that one's a little bit different because it was defensive. That was it's a threatening motion, and it's just challenging from the perspective of like having something kind of personal at stake. You're going to be more nervous, I think, about being accused of wrongdoing than you are going to be about, am I going to win or lose this motion? The stakes are so much different. So this is, from my perspective, just going to be Alessi arguing a motion that he's not. I wouldn't give him the odds on it. If I'm the bookie in Vegas on this motion, I'm not giving him the odds on this motion. So he's the underdog. I can't wait to see how he handles that underdog position. Oh, Andrea, I wish you could read the chat. We have comedic geniuses, so funny and clever. Love them. We do. We have a wonderful chat. And it's kind of like part of the reason why I wish court would go ahead and get started is because when I'm not having to read stuff and like think off the top of my head and talk a lot and stuff like that, I can actually look over at the chat from time to time and see what's going on and keep up with you guys, because yes, you are so extremely clever. One of the things I love about this chat that has just consistently impressed me is the brain power we have in this chat and the expertise we have in this chat. I can't count the times where there's been a technical issue that's come up about, cell forensics or about, crime scene investigation or pathology or something like that. And here we have, in the chat, oh, I was a 20-year crime scene investigator, and here's, it's just, it's awesome to me. I love this. I love this community that has formed in this chat, and that takes an interest in these cases and contributes that knowledge and that expertise so that we can all have a better understanding of it. It's super awesome. Nicole Rico, hey Nikki, good morning. I'm ready to buy some wall art. Who did you say you got your beautiful fish from again? The beautiful fish are from Heidi Elkington. I might be able to drop the Instagram link in the chat. She is Heidi Elkington Art. And her art is absolutely amazing. She does a little bit of everything. She does metalwork, she draws, she paints, she's been doing glass stuff. It's really amazing stuff. And so even if nothing else, following her Instagram is awesome because she's very productive. She's always creating new things and sharing them and stuff. So Heidi was down in Chile with me for a few weeks during this last trip. Heidi she's like my soul sister, man. I love this girl. She's amazing in so many ways. But so you'll see if you do go check her out on Instagram, a lot of her recent art has been inspired by that trip to Chile. Just kind of recreating some of the things we saw. I'm just going to go ahead, since we got the time anyway, I'm going to just go ahead and share her Instagram page because why not? It's just so awesome. This is her, and just the different kinds of things that she draws. This one right here, this is the Pablo Fierro Museum. This is in Puerto Varas, Chile. It's one of the coolest like art houses I've ever been in. And so this guy Pablo Fierro, he's like an architect. He seems mainly like an architectural artist. He does lots of drawings and paintings of different buildings. But he did other things as well. Like he has, there was a whole series he did of different birds and things like that. He's done portraits, self-portraits and stuff like that. But architecture is very much a key part, a big part of his portfolio. So at some point in like the early 2000s, he had a museum, I think a small museum in Puerto Montt, which is a port city right nearby. And the city of Puerto Varas offered him this building that was the old pump house for the city, where the water, the water station where the water would be pumped in. They, got a new water system, and so the house was old, and the house was not being used for anything. So they went ahead and gave it to him to basically have this museum. And I don't know if you can see my cursor here, but this little section right here is basically the original pump house. And so everything else he built. He built and he added on and he modified and like this big boat. She didn't draw the buses over on the side. Like there's a big bus that's parked here that is built into the house now. Like you can follow all these strange pathways and staircases and stuff that go all through all these different rooms, and they're full of all kinds of different knickknacks and obviously his art and stuff. It's just fun. It was just a really, really fun place. So I love this particular drawing because, that was a good time. That was a good place. But yeah, this is a lot of Heidi's art. A lot of the stuff that she does. We go down a little bit further, we'll get to some more of her metal. Well, here's a bunch of her glass. So many drawings. I mean, almost every day she's doing stuff. This is where she did Iron Man. She did the first 70.3 Iron Man because she's a freaking badass. That was pretty amazing. So yeah, you can scroll and scroll and scroll and scroll. Here's a metal piece. That's a metal piece that she did. Get Free was a show that she did. It was like the theme of the show. I've got a Get Free sticker like that. I got a Get Free sticker on my car. So anyway, have fun scrolling through Heidi Elkington's Instagram because it really is amazing. There's a lot of cool stuff there. She's a spectacular artist. There's a metal thing right there. She made this for me. This is my dog Buffy. And she made this for the chicken coop. We had a little bit of an issue while we were building the chicken coop because it wasn't entirely secure, in the process of building it, but we already had the chickens. And so we had a couple of escapes. And unfortunately, this dog is a bird dog. I mean, Vigilas have been bred for hundreds of years to be bird dogs. And she is very, very birdy. So unfortunately, the escaped chickens never stood a chance. But now they have their warning. They have their warning in the sign out there at the coop. Beware. Beware, the bird dog is waiting for you out there. So it's all secure now. We haven't had any issues since then. So that's Heidi, and that's her art. And thank you so much for asking about that. Well, still waiting in the court there. Yes. Your Vigilas would have gone for chicken too. No question. No question. The chickens are just far too tempting. I'm not a hunter. No, I'm a vegetarian. not entirely, but mostly. Although I could tell a story about I did eat meat for just about the first time in almost 20 years while I was down in South America. Maybe I'll tell that story in a minute, but yeah, so we haven't trained her to be Birdie, but we got her Buffy's our third Vizsla, and we've gotten them all from the same breeder. She's over in Ephrata, and they have fair amount of property. The husband is a hunter, so they're wonderful people. They have a long relationship with the Vizsla Club of America and AKC and all that kind of stuff. So they have always gone to a lot of trouble to like socialize the puppies and expose the puppies to a lot of different stimulus, and the birds are very much a part of that. So the puppies get exposure to the birds very, very, very early on. And so Buffy had that, Buffy had that, and she definitely has the instincts. I think she would be a very, very good bird dog. For somebody who was inclined to go out and hunt the animals and eat them. So I'll tell you the story about the eating meat. It was down in Puerto Williams, which is on Isla Navarino, which I've mentioned. It's southernmost city on the planet. If you were going to flip it over to the northern hemisphere, like the equivalent latitude, it's roughly north of Edmonton. So it's not like, relatively speaking, crazy. Like we're not even quite at Alaska yet. But because the land mass in the southern hemisphere, there's so much less of it than there is up in the northern hemisphere, it affects the weather patterns. So like there's massive winds down in the southern hemisphere, and that's part of the reason why like the graveyard of the Pacific is down there at Cape Horn. It has to do with how the Atlantic continental shelf, like there's the way that the sea floor is structured, creates a pattern that tends to create large waves, and then that gets combined with just these absolute insane winds that will go through this area. And so they'll get the monster waves, the rogue waves and stuff down there, the ones that a container ship will just sort of vanish off the radar because some rogue wave, 100-foot wave came through and took out the ship. So it's kind of an extreme climate, extreme environment down there. I went down there and I did a trek for 5 days in this area called the Dientes de Navarino, the teeth of Navarino. It's just this, it's this lovely mountain chain that's actually, it's the southern end of the Andes. So the Andes run into the ocean. They fall into the Pacific Ocean, like towards the southern end of Chile. They're much, much taller in the north than they are in the south. So in the north, you have like Aconcagua, which is the tallest point in South America. But down in the south, the peaks of the Andes are much, much lower. We're talking more in the ballpark of like 3,000, 4,000 feet. And it just has to do with that, the uplift, the way that the mountain range has been formed. So I'm down at the very, very southern point of the continent, the lowest point of the Andes, but it's still a lot of the same types of features that you have in these mountain ranges in the south, where you have these extrusions, and they've been carved by glaciers, mostly by glaciers, but also a little bit by river, by water melt and things like that. It's seabed, basically, like ancient seabed that's been uplifted. Like you go to the top of the Andes range and you find ammonites and fossils and things like that, because it's all old seabed that's been lifted up by tectonic activity and by by magma, that is pushing it up. So I did this 5-day trek. It was amazing, wonderful time. And when I got back in, I was staying at this lodge. Now, like I mentioned, Puerto Williams, it's the southernmost city on the planet, but there's not a lot to it. There is not an awful lot there. It's maybe a couple thousand people. I doubt there's even a couple thousand people that live there year round. So when I was looking for where am I going to stay, because there's only flights to and from the island 1 or 2 times a week. So you got to fly in, I got to stay, I got to go on this trek, I got to stay until I can get my flight back, that type of thing. There were not a whole lot of options about where to stay. So I picked this lodge, and this lodge it's probably about 3 miles out of town. So it's nothing like so crazy that I can't hoof it into town if I want to. But, after I came off of a 5-mile trek, I really didn't want to. I didn't want to have to do another 6-mile round trip walk just to be able to get dinner or something like that. So I ate at the lodge, and it was one of those places where, there's not a menu. You're getting what's being cooked. You're getting what's being cooked. Now, they did have a vegetarian option, and when I had reserved and checked in and stuff, I'd let them know I'd prefer the vegetarian option. But when I went up for dinner, the plate came and they had forgotten or overlooked or whatever, and it was not the vegetarian option that was served to me. And so I just had one of those moments where I'm like, I could send it back. I could be like, well, I need the vegetarian one. I could, but it's already here. The animal is already dead. Like, it's already been cooked. It's just going to go in the trash. I'm not really achieving anything, by not eating it at this point. What the hell? I'm just going to go ahead and eat it. And so I did. It was a little bit spontaneous, and I ate the meat. It was these medallions, like these loin medallions, and it was on top of a risotto, and it had this sauce. It was really good. And so then later I found out that it was guanaco. The meat was guanaco. Guanaco is one of these South American dromedaries. It's like related to a camel, related to a llama. It is quite cute. Very sorry to say, it is quite cute, the guanaco. But it was pretty delicious. So take that for what you will. If you happen to be down in that area, perhaps try the guanaco if you get a chance, if that's your thing. I won't be rushing out to eat meat again anytime soon, but that did happen. So just thought I would share all of that. Flexitarians are the bestitarians. Well, of course my husband's going to think that because I'm, more or less flexitarian, but pretty much fish. It's been fish, is my main meat protein for a long time. Yeah, last time I do remember last time I ate some red meat, within the last 20 years, I want to say, I can't remember the exact year. It would have been in the ballpark of about 2010. And it was because Jeff and I went and visited my grandfather, in Montana. He was living, like just south of, Missoula. He was living in Hamilton. If you guys know the area at all, it's beautiful, beautiful in the Bitterroot Valley of Montana. His wife, my step grandmother, she had died. So at this point he was living alone, and, we went to visit, and we got in a little bit late in the evening. And so he had prepared dinner for us, and, he had gone and gotten these massive, thick, like beautiful steaks. I don't remember what steak. I don't remember if it's New York. I don't remember if it's porterhouse. I don't remember. But it was this massive, beautiful steak. And like, that's it. No sides, no bread, no salad, no nothing where I could just like pick around the edges. It was you're eating steak or you're not eating. Well, plus it's the fact that it's my grandfather, and he's trying his best to be very hospitable and very welcoming, and I appreciated that. So I did eat the steak that time too. But by and large, yeah, it's not something I do. I'm a fish eater, which actually Chile is phenomenal for that. It's one of the reasons, the question yesterday about going to Argentina. I will go to Argentina at some point. But it's one of the reasons why I really like Chile, and I prefer Chile so far, because they have so much seafood. They have wonderful seafood, and so it's available pretty much everywhere. They have this wonderful dish. It's my favorite one that I got so many times while I was down there. It's called salmon a la pobre. And what it basically is it's just a beautiful piece of salmon. When Chileans serve you fish, they're not messing around. You're not getting like a little 4-ounce, piece of meat. You're getting like a pound. You're getting a big old, thick slab of fish. So it's a great big piece of fish, and it is on top of a bed of papas fritas, which are French fries, basically, and some fried eggs. So fish, French fries, and fried eggs. That's salmon alla pobre. Oh, it was wonderful. I ate that so many times. They also have this fish that I enjoyed a lot. It's congrio. Congrio is this great big eel. It's like a giant eel. It's not like the little kind of soft, sweet eels that you get if you're into sushi and like Japanese food and eel sauce and all of that. It's not like that. It's a big one, and it's a very thick, sweet white fish. Like it's a nice fillet. It's a very, very delicious fish. And so there's a traditional dish, the caldillo de congria, which is eel chowder, basically. And it's so good. It's so good that Pablo Neruda wrote a whole poem about it. And Pablo Neruda is known for being a little sensual and romantic and stuff. Like, I'm telling you, this soup is that good that you can have those types of feelings about it, those kinds of vibes. So really enjoyed the caldillo de congria. Oh man, the last best thing that there is down in Chile that you can't get anywhere else. This beer. They have this brewery that's down in Punta Arenas. It's called Austral is the name of the brewery, and they make all of these different beers. The one that's like really common in South America is the Calafate ale. The Calafate is it's a type of bearberry. If you're familiar with that from gardening, it's like a prickly kind of evergreen plant, but it has a berry on it. So the Calafate is a type of bearberry, but it's a very sweet berry. It's a little bit like a blueberry. And anyway, they make this ale, this Calafate ale. There's a couple different breweries that will do that, and it's quite good. But what the Austral brewery makes that I just enjoyed so much, they made this whole line of lagers, these different lagers, a red lager, a black lager, a hoppy lager, a blonde lager. And I tried them all, and they're just fantastic. They're really, really good. I loved the hoppy lager, and I say this because kind of one of my beefs about the beer culture in the United States, especially the craft beers and the IPAs, especially stuff like Oregon IPA is like such a thing, and they put so much freaking hop in it. They put so much hop in it, and it's not balanced to me. It's way over the top. It's way too bitter. I don't enjoy it. I like malt in my beer. And so this hoppy lager, it had like this perfect balance of, it's a nice sweet lager, but it's also got that little bit of crisp, that little bit of citrus you get from the hop. It's a wonderful beer, and they don't. Oh, here we go.
Penalties of perjury this 21st day of February 2025. So the fact, what you state as fact, that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you what your good faith basis is for that, and I'd like you to start there.
If the court recalls the discussion at sidebar, we were told for the very first time, Your Honor, about this issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court with no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that, because that was the next conversation that we had. When we were told on the day of closing argument to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct by the jurors, or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously recognized.
You were not, just so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported. I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who are in charge of the jury?
Your Honor, I'm getting to that. I understand that. But if you'll allow me to make the argument and to indicate what as my declaration says, my good faith belief, based on a reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration, there was no report, there was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember, no. That was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
and
he has...
I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us, we were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
you were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was. Commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time, in good faith. Both Mr. Yannetti and I asked the court to take evidence from Lieutenant Fanning. The court
I think it was
declined.
Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, Here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals, or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly what
Does seem
we put in
reasonable.
our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access, he didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
There you go. Guess she doesn't have an
I will
answer
let
to
you
that.
Move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson. Well, put it this way. Let's say it this way. So, now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized?
Is
now
there
that
evidence
you know
that-
it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or
That's the point right
indirect,
there.
with any of the jurors? I don't
Now
know that
you
to be
know,
true. I mean, I take the court at its
because
word.
the Commonwealth says
Clearly, I
so.
take the court
We
at its
will,
word.
we
But
will move on from that, Mr. Jackson. We'll move on from that, so.
Well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason. Because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case, and he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access even in the orbit of the jurors directly or indirectly, and the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror. That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
All right, so that's your answer to my question.
That's my answer to
May I
the
have a
first
moment
question.
to confer with counsel?
Yes.
Well, starting off hot, aren't we? I think we all knew that was going to happen when Mr. Jackson was going to be giving this argument. We knew there'd be sparks. She just really wants to get him for an ethical issue, doesn't she? She really wants to go for the throat and try to get something. Advocating for your client, drawing inferences from the evidence, that's permissible. It's not only permissible, it's your duty. It's your duty. And yeah, the response, do I still know? There's no freaking evidence. That's a really important point because
Thank you for that.
so
The
much of what's
court
happened has
invoked
been the
Mr.
Commonwealth
Unetti, and
asserting
said
things.
As local counsel, he knows this not to be true. Mr. Unetti just indicated to me that that's not quite the fact. And so Mr. Unetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Unetti. So if the court would allow Mr. Unetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
Oh,
I'm happy to, Your Honor, and thank you for giving me
you
the
know you're not going to be able to do
opportunity.
anything, so you're ready to move on now.
The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers, through their agents has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers, but I want to concentrate my argument for the court this afternoon on the exculpatory sallyport videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the sallyport issue, or the sallyport video issue. The Commonwealth, to start off with,
She's going to be
two facts
pissy
that are
now.
true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also bring in a newly revealed sergeant, a sergeant by the name of DGM Petro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld sallyport video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious, so he's still around?
He is,
Okay.
yes, and is cooperative.
All right. All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations. And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the sallyport at Canton PD is of critical importance. And that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The sallyport video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got 2 videos. One was the sallyport interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the sallyport. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another sallyport interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant D.Jim Petro retired, we received 4 videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior sallyport. And I highlight the word exterior because it becomes extremely important in just a moment. These are 4 videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior sallyport was given to us. It's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior sallyport video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick, dated February 28th, which is 4 days ago, 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior sallyport. Exterior sallyport. That means that the Massachusetts State Police not only had in their possession exterior sallyport video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 25th.
Well, that's not good.
January 2025, and they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination...
So can I just ask, was this of better quality than anything you had had, or was it the same wobbly?
Same.
Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior sallyport video? We now know that Buchnick watched some sort of exterior sallyport video. He admits it in this report that we just got 5 days ago. And we also know
With
that
Lally.
Mr. Lally were reviewing video together before his testimony in May of 2024, as he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior sallyport video and intentionally withheld it from us. This is binary. It could only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously in error. It was obviously calculated.
Yeah.
Another important material fact not in dispute. On April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the sallyport. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right, and also could you explain to me the prejudice?
He didn't get to use it at trial.
As I move through
now
my
or no? If you can, if you're going to do it later, that's fine.
I will do it later. I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided.
Okay.
It just, very obviously, there were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them. On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true, and we're still getting video evidence that is in their possession, custody, and control in October, in January? How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But in point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition
Unbelievable.
was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these salary Sallyport videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it say it? What page
I
you on?
don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs.
Okay.
Crime scene photographs in support of the vehicle in the Sallyport. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sallyport. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years.
If nothing else,
before
this
it
is
was
going to be a
turned over
great
to us.
trial argument.
So it's the condition of the car at the time that it was brought into the Sallyport on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton Police Cruiser at 8 a.m. and the independent observations of Dighton Police Officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sallyport. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sallyport. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sallyport at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Sallyport, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. That's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote-unquote evolving. They write that the defense, quote, struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Sallyport, is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Sallyport. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video, it's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So who's
Talk about evolving. Yeah,
Ours
thanks, Ellen.
or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us, and this is something I think the court has to really weigh and balance the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the sallyport. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath. And all the while they were battling us on the time that it got there, no, the defense is all wet, they're wrong, they just didn't account for daylight savings time. Oh, no, this was just a little mistake, it's not a big deal, it was a Scrivener's error. And the entire time they're making both of these claims, they had video in their possession that established unequivocally that that car was in Michael Proctor's possession at 5:30 and pulled into the sallyport at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the sallyport until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the sallyport, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle to explain it, it's their struggle to acknowledge it. Of course that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the sallyport, would it show the condition of the taillight before Trooper Proctor had access to it in the sallyport? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. This is not a game of Wordle. This is not something that's supposed to be
Game of
parsed.
Wordle.
All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has, so we have to be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the sallyport videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the sallyport because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways.
Thank you, Ellen.
They write on page 4 of their opposition, quote, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's sallyport until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that sallyport video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case. Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does. The Commonwealth cannot absolve
He pulled it all at the
themselves
start of the case,
egregious
did
and
he?
very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue.
Yes, it is.
Commonwealth
It's
versus
correct.
Sleeper, 2002 case found at 435 Mass 581, and this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation.
Yes, it does.
And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor
Like
worked
Proctor?
out of the Norfolk
The
DA's
case
office,
agent?
physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or sallyport where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchanan and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video from the sallyport? Answer, I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get them for you, Your Honor. I
Okay.
didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish,
Of
that
course.
would be helpful for my review.
I haven't reviewed it, sir, in quite some time, so I can't recall what's on there. Question. Why did you review video of the sallyport? Answer. We review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Buchanan. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight. And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact, by his statement,
That was always the issue,
Michael
the
Proctor
timing
admitted that,
of how the
quote,
taillight
"we
got there.
pulled," end quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C, is it Charlie?
Okay.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But you have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. Hasn't been years. He further admitted that it shows the SUV arriving in the sallyport at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video, that was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says
Yeah.
the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents.
It doesn't
The fact that
matter.
the trial prosecutor, whoever that is, it's an interesting use of a name, of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this. But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin?
It's a defense
Both
to
of them?
Napoli, not to Brady.
And why are they only referring to one trial prosecutor when there were clearly two in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people. So which sentence goes with which person under oath? The single declaration is odd, to say the least, but it certainly doesn't define who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal materials.
Were those all from the Canton Police Station?
I'm sorry?
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications, or had daily communications, with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time, and it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, the quality of the video is poor in certain portions. However, this is the condition it was recorded in. Says who? That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We've got no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered. And these questions could be answered with a proper evidentiary hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton Police video system. We were not told that until well after trial. That was never disclosed to us, and I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed to as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was
After the trial.
defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear, and that's the camera that, according to the Commonwealth, was replaced as defective. A week after filing its certificate of compliance, after the defense brought to the court's attention that 42 minutes was missing from the sallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted. In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument. I didn't know. We did not know.
It was
about
your
its
duty
existence.
to know.
No matter how many times they write it, however, it does not change the Commonwealth's
And you certified that you
responsibilities.
asked.
It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Probably
She couldn't take her lunch early.
45 minutes, I would say.
All right, so we'll break.
Couldn't take her lunch at 11. Thanks, Judge. Very convenient. I did see Mr. Betterow there in the courtroom, sitting right there in the front row. Good to see him there. Would like to see him at counsel table. Not really sure what's going on with the status of that. I know, I remember he'd applied for pro hac vice, and then there was an order that Mr. Iannetti's affidavit was insufficient. Wasn't clear to me why it was insufficient, but apparently it was insufficient. I don't know if that's been corrected or what the deal is with that, so perhaps some of you in the chat know. Well, what did we just see? What did we just see? Well, they were already in session by the time the cameras got going, and Judge Bev was already jumping on Mr. Jackson. Already jumping all over Mr. Jackson because she is so eager to catch him. She's just positive that he's out here violating the ethics rules, doing unethical things, and she's going to catch him. She's just already got that in her mind. So she's accusing him of saying that in his affidavit under oath, where he states that Fanning had access to and control over the jury, it's not true. And so what's his good faith basis for that belief? That's not true. I'm the judge. I know that the court officers have access to and control over the jury. Court's a witness now, too. So what's the good faith basis? Well, AJ says, tries to explain multiple times, and she interrupts him and tries to correct him and argue with him. We had a sidebar where you told us about the suspected jury misconduct, and then they came back and asked the source, and were told that it was Lieutenant Fanning. And it was the court officer who had joined them at the sidebar and said that it was Fanning, and that they got that information from an unnamed person, and that even though the tip indicated that there was documentation, possibly video, none of that was provided, and that all of this information was third hand. So they had an agreed colloquy with the juror where she denied talking about the case. And then over the defense's objection, the jury was excused. This is improper. This is not good. This is not good, because you have to have good cause to remove a seated juror. And if they don't have firsthand evidence of what the juror is alleged to have done, either because you have the witness who made the report in there on the stand testifying about it under oath, or you get the video that is, you know, ostensibly supposed to exist, then that needs to be in the record to support the trial court's finding that there's good cause, because the good cause would be the juror engaged in misconduct. You didn't get that factual basis from the juror denied it. Well, you don't get to a finding that something happened just because somebody denied it, and maybe you think you think the juror isn't credible. It doesn't matter. You don't have the initial basis. You don't have the evidence in the record to be able to support that. So yeah, that's a problem. That's a problem with the dismissal of that juror, and I'm kind of honestly surprised. I guess because that's an appeal issue, it's not a new trial issue. The remedy, pretty sure it would be a new trial. I don't know. I don't know about that. I'm kind of surprised, having heard these details now, that this didn't get raised. Maybe in part in the context of the double jeopardy challenge. I don't know. Maybe this is just something that's going to sit out there, and if she is convicted and appeals, then it would be something that she would raise in the appeal, because it sounds very appealable. This sounds very appealable. You have to have a factual record of good cause to dismiss a juror. You don't get to just go in and cherry pick them. So that might explain a little bit about why Judge Cannone is being so hostile about this particular argument. She's in the hot seat. This is once again her kind of jumping the gun and doing things kind of spontaneously without having the record that she needs to be able to justify it. And this is the same issue she already knows she's on the hot seat about over in the federal court. Maybe that's why. Maybe that's why. Maybe it's just because, yeah, who has access to and control over the jury? That's in her domain, isn't it? It's typically the trial judge. Trial judge is kind of the ultimate arbiter of all that. The bailiff or whoever, court security, whatever they call it over there. Get an answer to the judge about that. So she's kind of a witness to that, potentially. So the justification is that, according to Mr. Jackson, it was the prosecutor who said he was the commander over all of the security requirements for the case, and that it's a reasonable inference from that includes the security of the jury, which kind of is a fair inference. I mean, we saw what was going on with people being led into and out of the court and so forth. People are getting escorted by MSP, and quite sure there was extensive security in the courthouse, throughout the courthouse, but the jury coming and going, yeah, that's going to be the That's going to be the main concern that they're going to have, because they're going to want to keep all of those protesters who were present distant, far away from the jury, so nobody can yell stuff at them or, otherwise taint them, so that their faces aren't out there in public. You got them out on a public street. Somebody might be able to snap a photograph of them or something like that. People following them to and from their homes. You're gonna want to make sure stuff like that doesn't happen. So yeah, 12 people plus alternates. Started off, what is 16? That's a big security arrangement, and that's gonna be the top priority. So yeah, it's not an unreasonable inference that the lieutenant of the MSP, who is the head of the entire security operation, would have something to do with that. And apparently, we still don't know. We still don't know what his actual role was, because nobody's testifying to it. There's no affidavit, nothing sworn under oath, and what do you think after day? You think Judge Cannone is going to say, yeah, we need an evidentiary hearing on this? She's not going to do it unless she's backed into a corner. She's not going to do it unless she's backed into a corner. Don't know if she can really make herself a witness. It's not the type of thing. So sometimes judges can take judicial notice of facts. It doesn't require evidence. It's just like such an obvious fact that that they can take judicial notice of it. I don't think this is that, because it's usually going to consist of things that are common knowledge in the area. So it can be things like, the name of the street out front. It can be things like just things that aren't reasonably in dispute. The local court rules and what they require, stuff like that. This is a specific fact. It's not something that's common knowledge. That's the whole point. If it were common knowledge, then you wouldn't need to ask. So I don't think she can just rely on her own insistence that Lieutenant Fanning didn't have any contact with the jury or any role over the security having to do with the jury, because I think it's quite a good point that he shouldn't be anywhere near it. He's involved in the investigation and the prosecution. He's an adverse witness. And so for him to be supervising people who had involvement in the jury operations, it's really not any better. He's their boss. So it doesn't look good. It doesn't look good to not have something on record, some kind of testimony establishing if Lieutenant Fanning was in charge of the extensive security operation. How did that relate to the jury security? Did they coordinate with the bailiffs? I would kind of think they would need to coordinate with court security. Did MSP troopers play any role in escorting the jurors to and from any other aspects of the security? And yeah, this whole question about how did this report come to Lieutenant Fanning in the first place? This report about the juror that was third hand and you know, undocumented and apparently accepted by the court as factual. What's the story there? That's a big red flag. The details about the dismissal of that juror, it's a red flag. That's an appeal issue. That's an appeal issue. You gotta have a factual basis that shows good cause. Otherwise, I mean, yeah, I'm pretty sure you might have another double jeopardy problem. Because that's the whole point of double jeopardy. You picked this jury. And so once jeopardy is attached, and jeopardy attaches when the jury is sworn, you are entitled to get your verdict from that jury that you picked. And the exception is unless there is good cause for one of the jurors to be excused. A good cause can be a lot of things. It can be they got sick. It can be, something came up, some kind of personal conflict, tragedy at home, something like that. Something comes up. It can definitely be misconduct. Misconduct is absolutely good cause to remove a juror. But you need evidence to show that misconduct occurred. And it doesn't sound like they got that. So this is messy. This is messy. This whole exchange where Mr. Jackson is explaining, okay, he's good faith basis. You insisted on this, judge. You led with this. This is what you want. So he's explaining how he led to this inference. He was led to this inference, and it was predicated on this comment from the prosecutor about Fanning being the commander of the security operation. And judge says, you were told at sidebar he wasn't. And AJ says, no, we weren't. And Bev says, yes, you were. I have the transcript. She has the transcript. Of course, the rest of us can't see the transcript. The transcripts have been impounded. Because it's going to be kind of important what that transcript says, doesn't it? Seems kind of important, but even if he's told at sidebar, it's court security that oversees the jury. It's not Lieutenant Fanning. He makes the point, we don't have evidence of any of this. We asked for evidence from Lieutenant Fanning, and the court didn't allow that. The court denied that. Boy, the double standards, man. The double standards when the Commonwealth asserts something, makes a representation about something, when the court makes a representation about something, it's definitive. We must just accept that. Why? Because they said so. Melanie Little's been pointing out the theme of this case, ipse dixit. Because I said so. But there's no evidence. Perhaps the court is willing to leap to conclusions to defend Lieutenant Fanning. That doesn't mean that that's factual. And that doesn't mean that there is substantial evidence in the record to support any kind of conclusion about what Lieutenant Fanning's role was. And it certainly doesn't mean I said so, therefore you know. No, that's not the rule about what knowledge is, as the court would be perfectly aware. Somebody says so does not mean therefore I know it, because ipse dixit is not the rule. It's not the rule. The court can definitely be wrong. The court could think. The court could think, believe that Lieutenant Fanning has nothing to do with the security over the jury, and she could be wrong because things could be happening that she doesn't know about. Coordination, communication, etc. So she really wanted this. She really wanted this to go somewhere to where she would be able to trap him. And the thing is, I'm getting an impression of Judge Cannone, because it still kind of blows my mind that she was a defender. It still kind of blows my mind a little bit. I don't think she was probably very good, honestly, because she's not very good at this. She keeps thinking she's gonna get him, she's gonna catch him, and she doesn't. And then I think she realizes that, and it annoys her, and then that's why she's got this attitude throughout the rest of the hearings. That's why she's got this grudge that she just keeps hammering on. She's not very good at it. You said so. Doesn't mean he knows. He wants it on record. He wants a basis. He wants something under oath. You could be wrong. You don't have the personal knowledge. So she's taking that very, very, very personally. Very personally. So I will go ahead, see if I can get us back to right when the hearing started. See if there's anything that we missed when they came live. It's going to be right about here. Let me go ahead and bring this up. We'll just see if there was anything that we missed while we were waiting for them to come live.
Knowledge.
Oh,
Signed
here it is.
Dismissed for extraordinary governmental misconduct, a true and correct to the best of my knowledge. Signed and sworn to under the pains and penalties of perjury this 21st day of February 2025.
So that's where they started. They started in the middle of her commenting. She's already going at Mr. Jackson, trying to get some kind of, admission from him, or trying to get him, off kilter, focusing his argument, not how he wants to present it, but putting him immediately on the defensive to see, I guess. I'm going to check law and crime and just see if they had anything going on. No, it looks like they started even later, unless they had a different stream up or something. Let me just go back to the very beginning of that one. Yeah, not seeing anything that precedes what we were able to see on Law and Crime. So I don't know, maybe by the end we'll be able to go back and check. But if anybody sees another stream or anything like that that's got more of the video from where this started, we can definitely go pull that up and check it out and see if there's anything in there that kind of adds to the flavor of how this hearing started off. But I think it seems pretty clear. She's confronting. She's doing cross-examination thing. She's confronting Mr. Jackson with what he said in the affidavit and the fact that he swore to it under penalty of perjury. And she is telling him it's not right. So explain to me your good faith basis for believing that that was a true and accurate assertion. And so he did. And she tried to interrupt him along the way. And I kind of feel like he was able to explain that. No, I don't know. Because I wanted Fanning on the stand to testify about it, and you wouldn't allow that. You signed this 2 weeks ago when you already knew he didn't have access to jury, AJ. No, we got to revisit the timeline now, because the first time that it was mentioned was when we got the responsive pleadings from the Commonwealth, and they assert that, and they do it without an affidavit. But it's the first time anybody took a formal position that he had no access to them. And she's like, you know, you knew it from the sidebar. He says, how do I know? There's no evidence. Yeah, that's right. That's right. I mean, it's just nuts. This whole thing is just nuts. He's going to know, supposedly, because I guess he's been told from on high by people who could be wrong and aren't under oath and so forth. Therefore he's supposed to know. Meanwhile, we've apparently caught Mr. Lally reviewing video evidence with Michael Proctor before he's turned this video evidence over to the defense, after certifying under penalty of perjury that he's turned all the evidence over, or he's done his reasonable inquiry, which clearly didn't happen, because the entire response that the Commonwealth has given here is that, well, they didn't know, only the other people knew. Maybe you should have asked, because that's what it means when you say you made a reasonable inquiry. And I remember somebody reminded me, I think it was on Twitter, somebody reminded me that Mr. Lally was talking in court when they were arguing about the DNA evidence, how the DNA evidence was late. And he was making representations to the court that he was regularly following up with the lab to check in and see what the status was. And then the defense got the communication records, and he hadn't talked to him for like a month. And who's getting put under the interrogation spotlight here in this courtroom? It really is unbelievable. It's so overt. It's so overt. And you know, it's not atypical. It's not atypical at all for the court to side with law enforcement and with the prosecution, to have their sympathies favor the prosecution and the investigators. It's not unusual at all. It's kind of normal. Very, very rare, just for example, to get have an evidentiary hearing or something like that and get a finding from a trial judge that the police officer isn't credible. No matter how much they lie through their teeth and how obvious it is. Very, very, very rare to get that kind of finding. They just always defer to law enforcement. It's not unusual, but to just see it so overtly demonstrated like this is. And I don't know what the explanation for it is. I feel like part of it is, like we just said, she's been trying to cross-examine AJ and trying to trap him, but she's just not very good at it. So it's possible she's just not that smart. It hasn't really crossed her mind that it's so obvious how much she favors the Commonwealth. It just hasn't crossed her mind, and she doesn't have the ability to strategize how to be more subtle, not be so obvious with it. That's possible. It's possible she just doesn't care because it doesn't matter, because nobody's going to do anything about it anyway. And they already moved to disqualify her. It didn't matter. Really is unbelievable. So I think AJ survived that one. He's not going to be, in ethical trouble because he advocated for his client based on a inference from the information that was provided to him at the time, and for which there is still no evidence that definitively establishes that inference was incorrect. I think the only way we get that is by putting Lieutenant Fanning on the stand to testify. What did it mean for him to be the commander of the entire security operation? What relationship did that have with the security operations of the jury? What coordination was there between these security operations? And then how did this report come to him? And what did he do to try to substantiate it or investigate it or anything? Usually, yeah, jury misconduct types of issues are going to go to the person in charge of the jury. It goes to the bailiff. They're the ones who would report it to the court. So, yeah, I just don't know about all of this. I really don't. So yeah, he should not have been in the orbit of the jurors directly or indirectly. Yeah, that's a proposition I definitely agree with. He's in the text chain about the nudes. And the reason why I think she has just let this go. She knows she's not going to get him. She thinks then she's going to get him through Mr. Yannetti. Well, Mr. Yannetti is local and he knows. Well, Mr. Yannetti is prepared to get up and explain why that's not exactly his understanding of the situation. And what does she say? Maybe later if we have time. Well, you're not going to find that there's a problem with what Alan Jackson said based on what Mr. Yannetti knows or should know when you're not allowing Mr. Yannetti to put on the record what he knows or should know. So that was like really her last angle, I think, to try to be able to get at him, this whole imputing that the whole defense team is bad. The whole defense team is bad. Because they're all responsible for everybody else. Certainly not applying that standard to the prosecution. But you gotta let Mr. Yannetti, if you're gonna make decisions based on what Mr. Yannetti knows, then you need to let him say. You need to let him put it on the record, what he knows and doesn't know. Maybe later if there's time. Yeah, we're going to be done with that. There's not going to be any sanction on Mr. Jackson for this. There's not going to be any finding that he did anything wrong. So the argument itself on the sallyport, he's starting to pick up. Of course, we're having lunch break in the middle of his presentation. Right? Of course we are. This is a mixed approach by the court. It's very easy to look at this and be like, oh, that's nice. She's cutting him off. She's breaking up his stride. But it's not necessarily a downside to have a break. You got a whole hour now to sit and think about, where have I already been? Where do I need to go? Did I forget anything? Did I miss anything? Is there anything I need to go back on and touch up? If you had to go through your entire argument, your entire, what he has said is going to be about a 90-minute argument, you got to just go through it the one time. You're doing it. You're not sitting back and reflecting about it while you're doing it. It's just, we're not that good at dividing our attention for the most part. So it's a really mixed thing. You know, there's a way to see this as you're getting an advantage, because you're having that opportunity to check back in on how you've been doing and see if you need to make any adjustment or revisit a point or anything like that. The real common theme here, yeah. The law enforcement knew about the video, and they apparently knew about it from extremely early on, because Trooper Proctor testified he downloaded it all. He downloaded it all and reviewed it all, and it's been some time. That's all imputed to the prosecution, the actions of the investigators. If he knows, they know. And if they don't know, it's not an excuse, because they should know. It's their duty to know. We have this new, he points out, this new Sergeant Petro is now entering the chat. Sergeant Petro. Don't know yet what he's going to have to offer, other than he's apparently recreating the chain of custody of what? This video? Other video? But Michael Proctor seems to say he got it all. This is why we're back into the situation where there's just absolutely no clarity. There have been so many explanations flying around and changing and going back and forth about the provenance of these sallyport videos. When they got them, what format they got them in, what they did with them. Now we've got a whole new one that I wasn't aware of. First it was you know, they were on the iCloud. Then it was they're on a hard drive. Then it's that they're on a file. They're like, you know, somewhere in a paper file, a disk in a paper file. And now we've got Michael Proctor downloaded everything early on, all the video. Who did what, when? That's what we need to know. And it's the fact that the Commonwealth is going to such lengths to obscure that and to try to make that as confusing as possible. That's exactly what tells me that that's where they need to keep pushing. That's where they need to keep pushing. That's where they need to keep asking these questions. Pin them down. There should absolutely be an evidentiary hearing on this. Are we going to get it? I think Bev has kind of shown her hand with her comments early on, her interruption. Is this exculpatory? How is this exculpatory? And how is this prejudicial? How is this exculpatory and how is this prejudicial? Well, great answer, I thought, on the exculpatory. because it shows the shadiness. All this video just happens to be malfunctioning and blurry and not good quality and so forth, and 42 minutes missing right at the critical point. And by the way, no, there's no backup. Nobody backed up, pulling out their phone, take a picture of that taillight. The critical evidence that tends to show that Karen Reed's SUV was involved in a car accident. No backup for any of that. I thought that was a really good answer. Because yeah, it tends to support the defense's argument that it looks sketchy for a reason, and that's because it is sketchy. It's an awful lot of coincidences, an awful lot of remarkable coincidences that the 42 minutes are missing. The ghost people are on the video. The video is inverted. All this other stuff is grainy and dark. I would love to know if the defense has been following up on, I'm not even sure like what the right word is, you know, administrative types of stuff concerning this camera. Have there been complaints about these cameras? When did they become aware that the quality was so bad? When was the decision made to replace the cameras? Why was that decision made? What precipitated it? How was it budgeted for? These are just more threads that you can pull, you know, to try to get a bigger picture of exactly what happened here. Because yeah, sure is another coincidence that one inverted camera, just the inverted one, was replaced sometime between January 29th of 2022 and sometime in like after trial in 2024? No record of that? When did the new camera come in? Surely there's a shipping invoice, a bill, an order, purchase order. Awfully coincidental, isn't it? So yes, the bottom line is they have had sallyport video since the moment they brought Karen Reed's SUV into that sallyport. They didn't disclose it until April of 2024. That's kind of the bottom line. They know the cameras are there, so they know there's video. And they didn't disclose any of it. They started disclosing it right on the eve of trial, in mid-trial, and then after trial is when all this video gets produced. So the timeline I thought was good. April 4th is when they get that front wall that's missing the 42 minutes. And then the one that shows from the garage that shows the SUV on the flatbed, but it doesn't give you the angle of the taillight. Those are the first things that they get. Then mid-trial is when they get the inverted video. And then 6 months later, just about in October, they get these 4 other ones that show Brian Higgins there. Then in January, they get more. They get more exterior sallyport video. They get the main drive. They get this report from Trooper Buchanan from last week. He writes a new report about what he was doing for his trial prep. So in May 2024, he was provided with a thumb drive and a CD with a label on his desk to review prior to his testimony. And it included the exterior sallyport video from the Commonwealth. But exterior sallyport video from the Commonwealth hadn't been disclosed yet to the defense. So they're watching it and they're prepping with it, including the fact that he reviewed it with Mr. Lally, but they've never produced it. So that's where she's getting at, because, you know, she wants to know what's the quality. Well, it's the same quality. The exterior sallyport video, it's poor quality, it's grainy, it's wobbly. She's already thinking past, this is definitely a violation. They've withheld it. They've met that prong. There's 3 prongs you have with a Brady violation. Withheld it, it's exculpatory, it's material. She's already past that. That's why she's going to jump straight to, well, is it exculpatory? That's where he's got that explanation that it's the cumulative effect. That when you look at all of this video and you see all of it just happens to be bad and not preserve the information that's most critical to this case, it's quite a remarkable coincidence. Quite a remarkable coincidence. And then they get to materiality. What's the effect? She's already thinking. She's already thinking past the withheld it. They obviously withheld it. It's crystal clear. They obviously withheld it. I don't know that we even need to spend any more time on that. The materiality, though, that's what's inviting Mr. Jackson to go through this recitation of the dishonesty and how they've presented it, how they have denied knowledge of it and then obtained knowledge of it, and Trooper Proctor is in the middle of all this, kind of all over the place with his knowledge of this video. That's impeachment stuff. Yeah, it's impeachment stuff. And it goes to that defense theory that it looks shady because it is. This all looks shady because it is. If it was all on the up and up, you wouldn't need to lie about it. You wouldn't need to misrepresent it. You wouldn't need to trickle it in. You wouldn't need to lose metadata. You wouldn't need to recreate a chain of custody. If it's all on the up and up, you wouldn't have to do any of that stuff. You would have just secured it, handed it over, properly documented all of that, identify who did what when. If it's all on the up and up, but it's because they're fighting so hard not to reveal any of that. And everything that does get revealed, the more that gets revealed, the worse it looks. The worse it looks for these investigators. And now Mr. Lally getting dragged into it too. So we have the binary that Trooper Buchanan reviewed the video with Mr. Lally in 2024 for his trial prep, and it could have only been one of two things. The inverted video that was presented at trial that was then knowingly misrepresented. You can see nobody's near the right rear tail. Nobody's near that tail light. True and accurate depiction of the SUV and the sallyport. It was very deliberate what they did, very clear what they did. Had they not taken that little extra step of pointing out the, so you can see nobody is near that tail light, I think it might slide. I think they could potentially slide, but no, they deliberately misrepresented what was on there so that they could create a false impression of what it showed. And so the fact is then when you go ahead and look at it in the correct orientation, you see, in fact, multiple people, including Trooper Proctor, right over there by the right rear taillight. While the ghost people are appearing and disappearing and all that. So it was either that or it was the exterior sallyport video that was withheld. Had to be one of those two things. So that's going to Lally knew. Lally knew. And this is after he had certified in April that he had disclosed all of the evidence. April 10th of 2024, he certified that he had disclosed all the evidence or made a reasonable inquiry. Now, that's simply not possible, as we've been establishing, because they didn't turn everything over. And their whole excuse now for why they didn't is they didn't make the inquiry. They didn't ask. We didn't know. We're not the bad guy here. The finger pointing when the rats start to flee the ship, that's a little bit of a tell. So it's after all this that then Judge Cannone starts interrupting. Yeah, we've established the withheld. We've established the withheld, and we're starting to get into some pretty deliberate misconduct types of arguments because they did it knowingly. Lally didn't sit there and review a video with Trooper Buchanan in June of 2024 before he testified, not knowing that he hadn't disclosed it to the defense. If it's the exterior sallyport video, he didn't sit there and, watch the inverted video and ask the questions, elicit the testimony about who can be seen near the taillight, not knowing that was extremely misleading. That the true and accurate representation of what was shown in the video in that context is not true. It's not true because it's actually inverted, and you knowingly omitted bringing that up. So we're getting into some more deliberate misconduct type of area now in AJ's argument. So that's why Judge Cannone then jumps in and says, "How is it exculpatory?" And his explanation, I think it's very good. The videos all happen to be wobbly or grainy or missing time. Or from angles that don't show you the condition of the taillight. All of that leads to the inference that the Commonwealth doesn't want you to see the condition of the taillight. Yeah, it's a pretty decent argument. A lot of coincidences. Out of all these cameras at a police station. And just not a single one happened to be functioning the way it should in order to catch some type of usable evidence. You're allowed to infer that it's because if you could see it, it would be bad. You are absolutely allowed to draw that inference. And so how is it prejudicial? We didn't have what we needed to be able to cross-examine the witnesses. Yeah? He's starting to get into now Louis Jutras. He's right. I remember that. The guy that testified, he testified about the library video. He didn't testify about anything about any sort of role with the sallyport video. None of that got disclosed. Michael Proctor, who downloaded the video, according to his grand jury testimony, reviewed it. We didn't have it. Can't cross-examine him about it. He says, I saw one very grainy video, then one of me and Trooper Buchanan arriving around 5:30. That's what Trooper Proctor testified to the grand jury, and he hadn't reviewed it for some time. The tying that into the timeline and the insistence that the Commonwealth had for so long that Trooper Proctor didn't even have possession of her car until 5:30. Nine times, including sometimes under oath. Meanwhile, there's a video that he's aware of that shows what time they arrived at the Canton Police Department. They arrived at 5:30. So the whole time he's swearing under oath, took possession of the car at 5:30. He's got information that that's not true. And yet they maintain that facade. They litigate it. They litigate based on that argument. And so the whole time he's making those statements under oath, he's got this video that shows it's not true. That's impeachment evidence. Now, where's the Commonwealth going to go with this? Oh, Trooper Proctor, he was already damaged. They already impeached him. They successfully impeached him. Well, they successfully impeached him on his texts. They successfully showed the jury this guy's a scumbag. But the Commonwealth spent a lot of time arguing in the first trial. Well, that doesn't mean he didn't conduct a perfectly clean and valid investigation. Well, this kind of thing goes to his investigation, because it means he's either misrepresenting facts and lying about them under oath when he knows better, or he's choosing to remain willfully ignorant of facts that would tend to undermine his timeline. Why would you be willfully ignorant of facts if everything is on the up and up? You just go check the video. The first time the defense said, I don't think this was at 5:30. They have the police reports from Dighton. I don't know when they got them, but they're going to get the police reports from Dighton and the CAD logs, and they're going to know. So wasn't it 5:30? So the first time you got that, you would, at the very least at that point, just go check. If you haven't checked already, you already downloaded the video, just go check. Oh, I guess we arrived at 5:30. I just had my brain, these things happen. They happen. It's not the end of the world if there's nothing sketch going on. And so his point too about the timeline of the search is why the timeline of the videos are so important. This isn't really, I don't think, I feel like this is a little bit outside of what he's getting at with the motion to dismiss, because we do already know this. We do, and they had that available at trial. That the vehicle, they knew the timeline of when the vehicle was towed, when it was secured in Dighton, when it arrived at the Canton Police Department. They already had that. They had that video. They had those reports. They had the testimony. So they were able to make that argument about the discrepancy, the window of opportunity between the car arriving in the Canton Police Department, sallyport, Trooper Proctor being near that car, near that taillight, and then minutes later, the search team begins the search, and then start to find these pieces of taillight. They were able to make that argument at trial. Now, granted, the inverted video coming out kind of in the middle of the trial is a little bit of a curveball. Yeah, they should have had that before. They should have been able to prep based on that. And there's no question that they weren't. But at the same time, they were certainly able to make use of that and show, the Commonwealth's whole argument here, there could not possibly be any type of misconduct by police because, look, you can't even see anybody near the taillight, even though you have ghost apparition people appearing and vanishing in and out of this video. So it's clearly, the video is clearly not accurate. It's clearly not, catching everything at every moment that's going on in that sallyport near that taillight. So yes, we knew he lied about it. He finally had to then say, oh yeah, it was just a scrivener's error repeated 9 times. When the entire time they had the video in their possession showing that Mr. Proctor took custody of it at 4:12 and got it to the sallyport at 5:30. I love that he got in the whole crime scene shenanigans. Yeah, I remember real clear. I remember real clear that previously the Canton Police Department was the crime scene. It was the crime scene to the prosecutors, to the Commonwealth. It had to be the crime scene to justify things that their investigator was saying. I remember that quite clearly. I thought it was also the phone. Didn't Trooper Proctor say he recovered John O'Keefe's phone from the scene? But he never went to the scene. And so later it became, well, the scene was Canton Police Department, because then Carrie Roberts testified she took the phone She took the phone. Great evidence security there. And she took it to the Canton Police Department, and that's how Michael Proctor got it. So, yeah, the Canton Police Department has been the scene for a while now until it's inconvenient to the Commonwealth for the Canton Police Department to be the scene. I mean, doesn't that just sum up? Doesn't that just sum up this case and where it's at so well? Things are the way they are until it's inconvenient for the Commonwealth, and then there's something else. The prosecutor says they weren't aware of this footage until they got the grand jury testimony, the transcript of Michael Proctor's testimony, which of course doesn't matter because they are presumed to know what their investigators have and are doing. It's imputed to them. There is no mens rea requirement for Brady. There's no requirement to show they did it on purpose. It doesn't matter why they did it. It's not knowingly withheld. It's just withheld. They withheld it. They had it. They didn't turn it over. So the only question becomes, who are they? And yeah, the law is real crystal clear. They is the prosecutor and their agents. They're folks that are involved in the investigation. So he saw a very grainy video, then one of him and Trooper Buchanan arriving around 5:30. He hasn't reviewed it for quite some time, so he had reviewed it a long time before his grand jury testimony. That they review everyone they pull. Looks like we're back up.
Go ahead and continue.
Thank you, Your Honor. When we left off before lunch, we were discussing the inverted video. In the moving papers, the prosecution indicates that, quote, the prosecutor had not previously received this video or knew of its existence. This is I don't know, it's the third or the fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they argue that point, it still doesn't change the fact that it prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps
Thank you.
It wasn't Mr. Lally, perhaps it wasn't Ms. McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them, and that's the galling issue. Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchanan with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth, during this debacle, had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchanan under direct examination by Mr. Lally, going into the next day, still under direct examination by Mr. Lally. They played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Buchanan about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Buchanan started having trouble with his memory about who was actually depicted in that video. We'll recall before I stood up on cross-examination, Under direct examination by Mr. Lally, Sergeant Buchanan was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was in fact Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case.
Yeah, where's their good faith basis?
The three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least, in its initial comments to me was, you may have said something that you don't have a factual foundation for. I think I have done my best to disabuse the court of that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle.
We already know.
Touched the right rear
They're not going to get
taillight.
the same treatment.
That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by three different individuals, you can just sort of say whatever you want in the motion. And I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court, that he, quote, never touched it. As a matter of fact, we would submit...
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. He's on the other side of the car. That's not the point. The point is, a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around the other side of the car and obviously was standing there for a reason. By himself, in a corner, out of the view of the camera, and then when the Commonwealth plays the video, it switched, and the intimation to the triers of fact was he never approached the right rear taillight.
It's getting fired up.
Taillight. And all of that
And
was
you
understood.
cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over, it was concluded, and the mistrial was declared, we're still getting videos that we can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutors sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which we need some facts. And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed.
It's their burden to disprove it
on behalf of the Commonwealth. And yet again, when it comes to this same issue, the Commonwealth recites this now worn out sentence: the prosecutor was unaware of the existence of these videos, end quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote.
Oh, that note's
LOL,
going to be in evidence.
laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
And what was the
discovery
date?
violations.
10/10/24 you received that? Was that the date?
10/10/24. That's correct. By the way,
Oh,
the
I remember when
Commonwealth claimed in
Mr.
its
Mullen
opposition
was
papers
lolling
that,
in front of the
quote,
jury
the prosecutor requested that both
about the
Massachusetts
lost
State Police and
lost
Canton Police
interviews.
Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why didn't
Well,
we
it
get
takes a
another
while
video in
to,
January of 2025?
you
What
know,
was the delay?
alter them.
How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DGM Petro, all had access to and knew about the videos. And then we have, on top of that, in the middle of trial, I think it was Mr. Lally, it may have been Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant and material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday, this past Friday. Additional reports
Let's hear
from the
this.
Commonwealth in a report from Sergeant DGM Petro, he reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested sallyport video of SUV inside sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume. Because I think the math in my head is it's 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested sallyport video again. of the SUV exterior footage. Quote, this is from his report, "I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton Police Station." End quote. He goes on to say, quote, "Due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting." This is the first we're hearing of any of this last Thursday. How is that? Sure. Ms. Little just handed me a clean copy of the DG and Petro report. I would like to have this marked and appended to our motion to dismiss if it's okay.
Sure.
The
Did I get that
entire
attached to
time
your motion
period.
to change the scheduling?
Of the SUV being in there.
You probably did.
So I've seen it.
Okay. May I approach?
Hold on, what, Ms. Little?
We'd still like to make it part of the record if that's
Sure.
all right, Your Honor.
I just wanted
Yes.
to know whether I needed a copy, because I have a copy, I've seen
Of
it.
course you want to make it part of the record. Oh, this is just looking worse and worse and worse. Proctor got it in February of 2022.
So are we marking it? So we need it if we're marking it.
Oh, I'm sorry. My mistake.
Exhibit 1 so marked.
Okay, go ahead, Mr. Jackson.
Thank you, Your Honor. The question is, how in June of 2023, now I'm going to go a little bit slow here just because it's linear. The argument is linear. In June of 2023, according to DG and Petro, he downloaded every single bit of video of that car while in the sallyport or while at Canton sallyport. How is
If
that
it's on a 30-day
possible?
overwrite.
How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day override. It's the only two explanations. Again, this is binary. So
Yeah.
in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DG and Petro, quote, it says, quote, "I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense." The "you and I" is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out, for the first time, that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DG and Petro admits that he, Rafferty, and the Canton Police Department had sallyport video that was material to the case. Remember, his quote was that "you and I believed may be needed to refute claims made by the defense." They were strategizing about how to defeat certain of our arguments, and they didn't turn it over. Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is, Chief Rafferty held on to it. She never turned it over. Probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DG and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day, it continues to be, the bulk of it continues to be withheld from the defense. And then we move to Sergeant Buchnick's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was the spring of 2022, he knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says
at
early
this
spring.
time, but it's sometime early spring of 2022. That's the best he can do in his report. Paragraph 2, in July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchanan with a yellow Post-it note. I further added Canton PD 12922 and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023. I did not review that video at that time. See the attached copy of the Post-it note. Final paragraph, in my preparation for trial in May of 2024, I was provided with a thumb drive and the CD labeled with a Post-it note on my desk. What's interesting is that the CD with the Post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little different.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No. No, it's pretty vague. It's passive voice and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony, so it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior sallyport. Exterior sallyport. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the sallyport, which was grainy and had a camera vantage point from the front of the sallyport. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall sallyport camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive, and the CD were returned. It doesn't say to whom they were returned.
He learned it was provided inverted. He didn't freaking notice it as soon as he turned it on by using his
Sure,
eyeballs.
do you have an extra copy for me?
I do. It does have one highlight on it. May I show it to Mr. Brennan?
Yes.
Are there two so marked?
So you do have an extra copy, Ms. Little?
I do not have an extra copy, Your Honor.
I thought Mr. Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
Do you have an extra copy? Is that one clean? No.
May I approach now?
Please.
Was provided inverted. That's why the was provided is so important. Who provided the video?
All right, go ahead.
Who
Thank you,
provided
Your
the
Honor.
video?
court asked probably the most important question about this report, which is, who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan? Who's at the center of all these sallyport videos? Who does he say was requesting the sallyport videos that he was acting as
Proctor?
the courier for in other particulars? Every one of those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Buchanan to review? It stands to reason it could have been Trooper Proctor. Seems to be reasonable. But I don't know because Trooper Buchanan doesn't say, but that would be another question that would be open to answer if we had an evidentiary hearing.
Yep.
Michael Proctor
Yep,
was
the
receiving
trail
the footage directly
should be answered.
from DG and Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this. None of it. Michael Proctor lied during his testimony, but he knew that we couldn't impeach him. There was no way I could impeach him. I didn't have any of these videos to impeach him with, because we didn't have any of the evidence that had been secured concerning that sallyport. Question: there's surveillance video from Canton Police Department sallyport garage that wasn't turned over, right? Answer: that video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm guessing
I'll
she
provide that to you
can.
in just a moment, Your Honor.
I love how Ms. Little gets to be the paralegal.
June 10th?
It was either June 10th or June 12th, but let me double check.
While she's looking for that, Your Honor, may I proceed?
Please go ahead, yeah.
Okay. The only thing it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing and a flatbed and the flatbed driveway footage outside the sallyport that doesn't show much of anything. It's now been proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie.
And Lally
The
would
video
have known
wasn't
it was a
discovered.
lie
It was discovered
too,
in February, at the latest, February of 2022, just
based
days
on
after this
what he
incident.
reviewed with
asked for
Buchanan.
it, and he received it, according to Sergeant DJ Petro. And it wasn't turned over either. None of it. But at trial, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is the definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible, with all this sort of years-long flurry that we've just talked about surrounding these sallyport videos, that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury? Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do. Is it reasonable? That's another question. To believe that they just knew nothing about this. We know Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter. In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor. And then we move to January 28th, 2025, this year. We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed into or driven into the sallyport garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the sallyport. The question then becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time, for the last 2.5, 3 years? And again, I've lost count how many times the Commonwealth makes the claim, quote, prosecutors have never seen this video, end quote. The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you, but it was the Commonwealth, in quotation marks, capital. The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who directed a review of all physical evidence and data files. I would have to guess. Again, I would applaud that. Should have happened years ago. What's most curious about this video, however, is that the prosecution now admits, quote, after inquiry it was learned that an investigator obtained this video
Which
from
one?
Canton Police Department in 2022. And it was placed in a physical case file, end quote. That's a direct quote from their opposition. They don't name who the investigator is. They don't indicate whose case file it was. They don't tell us where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from this admission by the Commonwealth that investigators did in fact download the Canton PD videos in 2022 before they were overwritten? That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went, and why we don't have them, and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. But it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote. In its opposition, it sounds like more of a desperate argument than anything else, that these cumulative, that these egregious errors
the
don't
poor
justify
quality
the
that
court taking any
benefits the
action
defense.
because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved. First,
Yeah, take issue
in
with that.
sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged, or unfairly treated, or suffered harm, or injustice. Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving. It doesn't work that way. The Commonwealth concedes that there's irreparable harm. They acknowledge that the forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time. It was their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith, and this goes back to the court's original question this morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that throughout this argument, but the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law. If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least, there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. And how many times do they have to say, we didn't know about this? It just doesn't matter. Like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know, through this new revelation, that it was intentional. The prejudice the defense has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards. Where there's misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice because dismissal is necessary to prevent the repetition of this type of misconduct. And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298. It's a 2017 case. even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and find that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial. The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them, to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. I've detailed those in our moving papers. And I want to incorporate all of those arguments by reference here as well. But relating to the surveillance footage itself, there's no question that the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5 or however many different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over, and it was just inadvertently withheld. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury. And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession, and it was also entirely withheld from the defense throughout this litigation and throughout the first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled? But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights. This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though, and it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic. For the Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence.
3
Now, I have
years.
to say, in terms of lesser remedies, Your Honor, what's interesting
They still
is
don't
that
have it at all.
the exclusion, obviously the exclusionary rule exists.
I understand that that does not help the defense.
It doesn't help the defense. And I appreciate the court finishing my thought on that. It's the opposite. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available. And that's what the law, and that's what justice demands. As a final thought, if the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues brought up here. This will give the court a much better understanding of the facts supporting dismissal, and it'll perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your notes. But Ms. Little, did you find the proctor testimony?
I did, Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just
Okay.
for the court's reference, lines 8 through 12.
Great.
Thank you.
All right, I have a question, Mr. Jackson, just about, so you argued obviously the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, and again, you just saw, I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked, rather than shattered and missing 47 pieces, as Dighton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding. I just took a quick review of Sergeant Barrows' testimony yesterday.
Oh,
on
for
being
Christ's sake,
prepared
you're
for
being
this.
deliberately
I didn't see
obtuse.
it
You
in
know
there.
he
Ms.
said it
Little,
was
do you know where that
cracked.
47 pieces is?
Yeah, the 47 pieces is not related to Sergeant Barrows' testimony.
Well, it sounds it from this, so I'm not to read it
You
this
are
way.
being
What Sergeant Barrows
deliberately
clearly testified to
obtuse.
was that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrows' testimony.
No, Barrows-
As Dighton Police Barrows testified. All right, where do I find that 47 pieces?
The 47 pieces, I can get multiple transcript sites, but those were the photographs the Commonwealth presented at trial, that there were that many pieces found at the crime scene.
It's the number of
Taillight.
pieces that were booked into evidence.
Okay,
Yeah.
great. Yeah, if you have trial transcript of that, I don't need 47 points, but if there's something that summarizes it. Because I took that to read as I see it reading.
No, Sergeant Barrows specifically testified about his observations of the taillight earlier that day.
Right.
It was uncontroverted that there were 47 pieces of taillight
Okay.
recovered at the scene.
That's not clear to me the way this is written, so I'm glad I asked you. Okay. All right, so with that, now, Ms. Tinetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you.
Hopefully we'll have
As I
time.
started with a question for the defense. So
What, you got a
I'd
date?
like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the sallyport videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court history as I've learned it about the production of video in this case,
Okay?
and it will explain in context the production of video and will help create the foundation so the court can understand and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you
Of course.
to clarify some of this. So know that that's what I'm focused on.
I understand clearly. In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the sallyport area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial.
Okay.
At that point, there had been no request by the defense for video of the sallyport area. What I learned is that Trooper Proctor had requested sallyport video from the Canton Police Department. And the person who was the custodian of Canton Police Video, who would download it from the DVR, was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29th, 2022. Sergeant D.G.M. Petro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D.G.M. Petro says that he downloaded the video in 6-hour segments, and that contained the front wall blurry camera inside the sallyport and camera in front of the police station. That remained with Trooper Proctor for some time. In June, around June of 2023, Trooper Proctor then made a second request from Sergeant D.G.M. Petro
Even though we already had it?
for different cameras. He wanted cameras, camera angle of outside the sallyport area.
So
when the
outside
tow
of
truck
the
dropped
30-day
car off,
overwrite.
leading into the sallyport, which is now characterized as the exterior sallyport video.
So when did they
Again,
change the
Trooper
overwrite?
Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior sallyport video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal grand jury, essentially he testified or was asked about video and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video.
Oh, I bet he
Inquired
did.
of whom?
Trooper Proctor.
Okay.
This is shortly before trial. ADA Lally was given a copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022, shortly after January 29th, 2022. I'm sorry, it was provided April 4th, 2022.
The entire time frame for
2022
those
or later?
cameras?
No,
It was later, right?
was
Because
later.
the
It was-
federal grand jury was later.
he provided it on the eve of trial. So it was April 4th, 2024. So we know this production on April 4th, 2024 was in the hands of Trooper Proctor shortly after January 29th, 2022. At this point, the prosecution team is still unaware of the June 23 production, which has Trooper Buchanan's name on it, which shows the exterior sallyport. As trial began, there still was no specific order or request. The chief of police saw something about the trial, and let me rephrase. Prior to the trial, it's reported that Attorney Yannetti was discontent because the video of the front camera sallyport was so grainy, intermittent, and not continuous. And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Yanetti's concerns, then asked Sergeant D.G.M. Petro to see if there was another camera or to produce any other video from the sallyport. Sergeant D.G.M. Petro then downloaded video from the DVR, which is the second camera that is inside the sallyport, known as the
So
inverted
when's it
camera,
overwritten?
or now characterized as the inverted camera. That was produced April 23rd, 2024, given to ADA Lally, then given to the defense. And so at that
When
point,
was
there
the
are three
overwrite?
video productions that exist. The first turned over to the defense April 4th, 2024, the second April 23rd, 2024, and the June 23 production of the exterior sallyport has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial,
When did they change the overwrite?
one of the employees from Norfolk County, Colleen Crawford, went to the sallyport and looked at the DVR system. And when she looked at it, she saw that video still existed on that system.
Ooh.
Although there was a 30-day overwrite on that system, the system had a number of backup hard drives, and because of the backup hard drives, the video existed longer than 30 days. She wrote an extensive report that was turned over to the defense, and this is after trial. The report notes her investigation about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note. I learned that that video was copied during the trial, and it is noted in the sergeant's letter. The chief of police and the sergeant were downloading video, not in response to a motion to compel or produce, but rather because they had concerns about accusations that were being made about the department, and they were saving video, in their opinion or from their perspective, to help defend against future false claims against them. They downloaded a number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately.
Downloaded them from where?
The
Downloaded
issue came
them
up
from where?
regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it, I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I said. And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station, I learned about the videos, and then as a consequence, I spoke to the chief, other officers, and the sergeant. Unexpectedly, the sergeant told me that he would click and drag copies of video when he would download them from the DVR. Inevitably, we had the litigation about whether the defense was going to download in person or not. And then, as I tried to finalize my investigation into the tapes, and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything, so I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my review. At that point, I was provided by Trooper Tully the June
Tully.
2023 CD with Trooper Buchanan's name on it. That is the exterior Sallyport video. And within 24 hours, I provided that to the defense. I then asked both the sergeant and Trooper Tully and Trooper Buchanan to write reports. Since there was no chain of custody, I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
So you didn't
Do
ask
you know which investigators filed?
about the
this
override.
Trooper Proctor's.
So it was in Proctor's paper file.
Okay.
Your Honor, I have 3 separate arguments. I will proceed with the videotape argument since we've lodged into it.
Sure.
Now, the defense has made a number of conclusions that there was somehow videotape that was tampered with. There is absolutely no evidence whatsoever.
And
none.
why is there not evidence, Mr.
It's not even
Brennan?
speculation. There was no evidence. that
Why
any
is there no
videotape
evidence?
was
Isn't
ever
that the
tampered
entire
with.
point?
They say it, but there's none. I have seen none. They have produced absolutely no evidence that any video was altered or tampered.
The videos
The
kind of
defense
speak for
lodges the
themselves.
idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose, and again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something after I came in and looked. They would have not got this production in April 2024. They would not have gotten the production if the government was looking to hide anything. And so the idea of intentionally withholding or bad faith is just a
You still
characterization by
haven't
the
produced it
defense.
all, it sounds like.
The words Brady have meaning. Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There was none. There was none.
No, that's not what they argued.
Trooper Proctor had this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have the same volume. They gave you a fragment of his testimony, which is about 3 sentences, but if you actually read a number of pages of his testimony that deals with this video, and it begins on page 133, what you will see, and I won't spend a half hour reading it, but what you will see is that Trooper Proctor was aware of the grainy video, which was the video that was provided right after January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton Police. And you can also see that he in no way was hiding the June 2023 video, because you can see the confusion between all the parties at trial. Attorney Jackson is asking Trooper Proctor
What?
about video, and Trooper Proctor is explaining there is a sallyport video, and also there's an exterior video outside the sallyport. And it is clear that Attorney Jackson does not have that June 23 exterior sallyport video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the sallyport and there's the exterior video. So clearly, Trooper Proctor was aware of the exterior sallyport video, but it will be clear from the reading of his cross-examination that there was no intentional withholding. He should have, since it was in his possession, whether it was relevant to the government's
How's
case or
that
not,
gonna be
he should
clear?
have provided it to the prosecutor, and then it would have been properly provided. But it was his oversight. There was nothing intentional or advantageous about it, because he struggled to try to explain to Attorney Jackson. And so,
Because he's under oath.
that Attorney
He has to
Lally
acknowledge that it
never had
exists.
an opportunity to ask more details about those. He has the opportunity, but he doesn't ask more details about that misunderstanding because he's wholly unaware that it even exists. It's a confusing moment, but it clarifies that there's nothing intentional whatsoever about this course. And so it's important that although the defense now suggests there's something exculpatory about it or something about it that's important, it is important to note that the defense never filed a motion for the production of the Canton Police Department video.
Because they don't have
It is not
to.
incumbent or assumed that the Commonwealth is going to obtain every video from every part of a town during an incident. It's not assumed that they will do that. The Commonwealth seeks evidence that they think is exculpatory, they seek evidence that they think is relevant and material, and when they receive it, they are supposed to provide it.
Yeah, like
There are
Proctor
many
did in
cases
2022.
Where video from a police department is never provided to the defendant unless they ask. Or many cases where it may be a video of the booking, but not the hallways, not the bathrooms, not the back parking lot. Put in context that the defense theory was a evolving theory throughout this case to this day. The defense theory was that it was some third-party culprit, unidentified, who committed
The
this
defense
act
theory
that
has
led to the
been
death
Karen
of
Reed
John
was
O'Keefe.
framed
In
from
fact,
pretty much the
you
very
can see
beginning.
Earlier interviews, the defense position publicly was, you know exactly who did it, intimating that there was a specific person. Now that recently has changed. If we see the recent interview 2 weeks ago on Fox 25, the quick answer was, we have no idea who did it. We don't have to know. And so this fluid position is not notice to put the Commonwealth on notice. They're supposed to chase down every potential idea or creation that the defense has.
They're not asking for video of the
It's
Alberts or Colin versus Alley
To
versus
look at
Higgins or
the
whatever.
motion that has been
Framed
presented
by
to Your
dirty
Honor
cops.
On behalf of the defense, where they claim that they moved to preserve video evidence. And when you look at that motion, the best it says is that they moved to compel physical evidence. That does not put the Commonwealth on notice of video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know that the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
Okay. And so, Attorney Yannetti, and I've mentioned this before, was very prolific in his pretrial discovery motions, very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't.
Because they didn't
fact,
know it existed because you
When
guys
you
sat on
look
it and
at
didn't
the
disclose it.
perspective of Attorney Yannetti, you don't have to look much further than his characterizations of how he sees the difference between the crime scene and the Canton Police Department. I've attached, for Your Honor and for the defense, exhibit number 4, trial testimony of Trooper Nicholas Garino. And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75,
Oh,
if
boy.
you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And Mr. Attorney Yannetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it? So
Oh, it was
the defense is
Guarino
hard-pressed now at
who
this
got the
moment where
phone,
they are trying to create
not
prejudice that
Proctor.
doesn't exist, to try to convert a motion that they filed with very specific intentions for physical evidence to now suggest that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert.
But we already
In
talked about Michael
argument,
Morrissey
Attorney
saying it
Jackson
was.
Characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever. But if you look at Trooper Buchanan's testimony, on June 6, 2024, if you start at page 103, Attorney Jackson, and to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position or about what he saw, or that Trooper Buchanan admittedly saw the inverted video. Not the case. Trooper Buchanan reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation in May. And he did not say that he sat down with ADA Lally and watched the inverted video. He was asked, were you shown any of the videos that you've seen in anticipation of your testimony? Now remember, there's not just Canton.
So he said in his
video
report
at that
then,
point. There is video
that
from
means he
Brady,
saw the
Town
exterior
Hall, a number of
sallyport with
different
Lally
places.
that
And he
wasn't
said, not during the
produced.
first meeting, I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the sallyport that we saw yesterday, correct? He says, Trooper Buchanan, I'm just trying to remember exactly what video I saw. I have reviewed videos outside of our meetings. That is what he put in his report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. He answered, yes. I'm on page 104. And that was with Mr. Lally, correct? Trooper Buchanan, clearly. That is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense.
Because the defense is based on his new report,
The conclusion
not his
they actually
testimony.
reached that Trooper Buchanan watched this video with ADA Lally in preparation for trial, therefore it is a lie that the Canton Police Department provided the inverted video sometime earlier. That's sworn testimony. Now, again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and
The
Mr.
butt
Allen.
dials.
And so you have to look at it in context.
Oh, now
rather than say it's
context
an
matters.
unequivocal denial and there's an aha moment. There is no aha
Oh,
moment.
so the words matter in context, you're saying. How novel.
So,
Do you have the grand jury cite? I think I might have got it from Ms. Little earlier, but the grand jury testimony of Brian Higgins, I have it. It's just easier if you have a cite to that.
I have a tab, but I don't, perhaps Attorney
I'm sure
McLaughlin
Ms.
does.
McLaughlin can get it
I'll
from.
provide it momentarily.
All right, thank you.
So what really arises from the subterfuge is that the defense did not ask for video. There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor that wasn't. There
So he
was
still
nothing
hasn't explained the drips
done
and
to
drabs.
alter or taint the video. There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's testimony, there was
And these
no
are
effort
also
whatsoever
assertions
to
that he has no
find it.
knowledge of.
It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering. And so ultimately,
Because that wasn't
the
preserved.
import of the defense's argument is that this evidence, this information, is
Still haven't heard
exculpatory.
when
It's
they
exculpatory
changed to the
because
30-day
what they
override.
claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barros's testimony. And if you have an opportunity to look at his testimony on page 12, line 1, the defendant told you part of the story. I saw there was some damage to the rear taillight. To my best ability and recollection, that taillight was not completely damaged, it was cracked. But they forgot the next part. And there, pause, a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on.
No, it's not, because you
After it's at
reconstructed
Canton.
it and there was a piece
The entire
missing.
taillight's not
Remember
missing.
that?
There is a piece missing. That piece, where the fractures of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so it's not simply cracked. Even the witness they tried to lean on, Mr. Barros, says more. And so if that taillight is not just cracked, if that taillight is missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring. Because
But that's not
there
what
can be no
Barrows
plan
said.
of fractured taillight if it's already gone before it gets to Canton. There can't be. And so when looking at the evidence, it is
So that's not what he testified to.
clear that piece of the taillight is missing well before that car ever gets to Canton.
Yeah, definitely not
And so
clear.
we can quibble and we can dispute.
Let's go look at the
and we can go
photo
back
of
and
that
forth all day,
reconstructed
but the best
taillight
way
and see
is
the
to just
piece
show
that's
the evidence.
missing
And so when we look
after
at
you
the
recovered all the
evidence,
47
let's
pieces.
start first with the fact, the claim that the sallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition.
Where'd they
Inverted
get those
for the
from?
back wall and fuzzy for the front wall. And we have those, and we've turned those over to the defense, and I just want Your Honor to see a small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before Ms. Reed's Lexus hits the sallyport area. Now you can see, if you stop that, please. Thank you very much.
Oh, you
On
know
that
what's
wall,
weird is
on
how
that
this time the
garage
timestamp
wall
is not
before
inverted.
it is
You remember
back.
how the timestamp was inverted?
This sallyport video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan. It was in existence well before Miss Reed's car showed up to that sallyport. Similarly, front wall camera, could we please put on exhibit 3? Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the sallyport. And you can see the quality. It wasn't distorted on purpose. It wasn't manipulation by the state police. This is the way the camera worked in Canton. Thank you very much. And so the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen. Now, what we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at Exhibit 6, please. This is
Oh, so
from the
we're gonna
ring video of
relitigate
John
the
O'Keefe's home. This
what the videos and the cameras and
evidence
stuff all
directly
show.
contradicts the idea that the sallyport video is relevant to show any break or plan of evidence. As Miss Reed nudges into Mr. O'Keefe's car, she will pull forward and will stop the video in two spots so you can get a clear look
And it moved.
of that rear tail light missing. Forward, please. Thank you. And then ahead one more. You can see the white light shine. Stop. You can see it clearly missing. You can't plant something that's already gone. And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white. The defense position is also contradicted by the ARCA witnesses. If we look at Dr. Wolf's testimony, day 31 of trial, it's noted as Exhibit 10 in our package, page 36.
Gonna talk about the
A.E.
Cannon.
Lally asks the good doctor, now doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no.
Yeah, no,
We provided notice.
not that
of our own
damage.
expert.
It would crack
And
it.
there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight. The defense position is also contradicted by dash cam footage. Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that that taillight is missing well before that vehicle makes it to the Sallyport area. If we could play Exhibit 7.
This isn't helping his argument because it's just re-emphasizing how important that Sallyport video is
If you could close up to the court, please.
for the defense
You
case.
compare the right side to the left side. Although covered and impacted by snow, if you could close, more close-up, please, you can see that taillight, just like the detective in Dayton said, just like the 508 ring video shows, is missing. Is missing. There's no plan. The defense's position is also contradicted by the alarm.com video that we received pursuant to Rule 17. There are two videos, 8 and 9. If we could play Exhibit 8, please. This is the defendant's car arriving in Dayton in the driveway. The defendant on the passenger side, and you can see them walk to the back of the car near the right taillight and stop. And if the question is, what are they stopping for, we can play video 9.
Because we've acknowledged
car
it's
is being
cracked
put on the
from when
profile.
she backed into John's
Before.
car.
It makes it Canton.
Ugh,
Just like 508,
he's just relitigating
in
the
driveway of
the
Meadows,
Commonwealth's
Robert
argument
Alessi,
here.
see that right taillight shine
But that's the
white,
whole point.
showing
It's an
the missing
argument.
Taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
You cannot.
Can you zoom in on it?
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better, and it's very clear, the white light missing video. I cannot see it clearly on the screen.
So will you give me a flash drive of all of these exhibits?
Oh, there we go.
Okay.
If you look at it on a small screen, see right there?
I do see it.
Yep, and then you'll see it again. So the alarm.com video contradicts the defendant's position that there is anything exculpatory about these sallyport videos. In fact, this whole idea of third party or plan doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense's position that there's any relevance to the sallyport video, that there's any type of plant by anybody, is from the defendant herself. Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court,
That's consistent with the defense
the
theory.
production should have been sooner, it should have been cleaner, there should have been a
Go look at that
log or
reconstructed
entry.
taillight and the
The failure
pieces
to
that are
provide was
missing.
inadvertent, it was
Oh
unfortunate.
boy, I've got it in my
Shouldn't happen, but it's not Brady. It's not
my file
exculpatory.
somewhere.
It's not intentional, it's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that that light is missing before the car makes it to the foot of the sallyport, so there can be no claim. That is my argument regarding the Rule 14 issue. I would like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf, but it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
The claim of jury tampering is probably one of the most serious claims that one can make because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen because of the collateral consequence of tampering with the jury. It would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion to dismiss, it's not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage. And why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so, how does one propagate a claim of jury tampering when there's no evidence? Well, first, you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence. Just saturate the public. Now, it's important.
Oh, for Lord's sake.
It's important to see or hear or read what is said. Because this really is the acorn that is being planted that cannot be rebutted. And it's not insignificant that this same information before this interview is being disseminated by Mr. Cannone. This idea that there was tampering by Lieutenant Fanning. Not a coincidence. And so during this interview that the defendant and the attorney have, the question's asked, I don't know why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question. One of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury? Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well into trial, as a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question, is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
Okay.
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand. I may be mistaken. We produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
Was that the juror interview with Turtle Boy?
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively, the next step is they have to identify a target. Who are they going to blame? Who's going to be the villain? In this case, the villain goes from anybody that gets in the way.
Oh, the
It
Ted
could be a
Daniel interview.
soccer mom.
Okay.
It
Thank
could
you,
be
Chat.
A police officer. It could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired state police officers.
That's why he's in the text chain
Massachusetts.
about the nudes. That didn't Tully get reprimanded
After
for
having
failure to
his name
supervise?
attempted to be sullied, all
He's the
over
commander?
social media, attacking his integrity and his name. I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation. But it happened. When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning. You look at
These
this
guys
motion,
really need to
page
learn that
15.
pearl clutching is not a defense.
It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior.
Correct. And
As a
Tully
result, he
was disciplined for
investigated by
that,
the Office
that
of
failure.
Professional integrity and accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They try to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received verification of that through the Pleadings Council, was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Yes, it was last year, last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
If I may, Your Honor, sorry. It was July 17th, 2024.
He is similarly situated to the many first responders and witnesses in this case. And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury, and he had access to the jury. Think about what those statements say to our community. We're going to pile
They
in
haven't
there
been
less than a month
disproven.
to try to give a fair
Have
trial
they?
to both sides. Think about what those words mean. After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion
We're going to go back
of
into the
this grandiose
projection
habit
now.
that is running amok.
Talk about, remember those
Trying
texts?
to get the community
Choosing
to
the
think
the
Fanning
target and
controlled, had
dehumanizing
access
and
to tamper with the
degrading?
jury. Think about,
Yeah, I remember what
that
they said
concept.
about Karen.
not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat of trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges. They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police.
Yeah?
and
You're saying
abscond
that's
from their
impossible?
duty and responsibility
I don't
to
see
protect
that.
jury, with no basis whatsoever.
You're going to tell me
That
there's
is the
never been a
concept
bad court officer
that they
anywhere?
are promoting in this
Ah.
motion.
We can find cases on that.
The trial court personnel throughout the state are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every
This
case.
is
in
just
jury
ridiculous.
instructions, to
God,
protect
why
the
don't you
jury.
just spread his cheeks a
And these
little
trial
wider
court
while you're,
employees, especially here in Dedham, some of the finest, would never have sworn that duty, and yet it is now in the public domain, this suggestion. The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts for the record. Fact: Lieutenant Fanning was not in charge of juror security. Fact: Lieutenant Fanning did not have control of the jury. Fact: Lieutenant Fanning did not access the jury. Fact: Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required
multi-agency
numerous local
cooperative
police officers
effort.
and state police because of the bedlam that was created outside. Fact: Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact: at all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here.
These aren't
Never
facts.
meeting a
These
juror,
are
never looking at a juror, Never
allegations.
being seen by a juror.
Put Fanning on the stand to say them, and then we have facts. Or just
No
in an
evidence any
affidavit.
trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning. Fact: Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact: Trooper Fanning never investigated, approached, or inquired. He heard the information and provided it to the trial court as is responsible, dutiful, and proper. And I'll repeat one more time, Lieutenant Fanning never, ever, ever interacted, controlled, or met with any juror. Your Honor, these claims in the motion to dismiss have a theme. Different issues, same theme, same pattern, same effort. Your Honor should dismiss it outright, and we should move to trial. Thank you.
If I may, Your Honor? Yes. Thank you. We're going to address in reverse order some of the statements made by Mr. Brennan. And I want to talk first about this issue of juror interference, which is what we called it. These words matter. We've claimed that there's interference. He indicates that that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts that he very dramatically stated in just a second, because this is a fact-based inquiry, one that we asked for standing right over there at sidebar and didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None, zero. And he knows that. But an effort
pearl clutch and be
Create
emotional.
an enemy where there isn't one. He acts
Triangulate.
like
It's
we've
triangulation.
insulted the court officers, which we haven't. He also said that Lieutenant Fanning stood up here and gave basically a CD, a resume for him, and said, the greatest guy on the face of the earth. I don't know Lieutenant Fanning. I don't know if he knows Lieutenant Fanning. I don't know the point. It's in the personality contest. He said that we identified somebody with an unassailable reputation. We identified him. We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen when somebody else identified him. Wasn't us. And by the way, everything that we filed concerning this was under seal.
Yeah, we didn't name
We didn't
Fanning.
disclose anything in any court document.
He disclosed
It wasn't
Fanning.
a public document, it was under seal. Mr. Brennan then states that he was also a subject, this person with this unassailed career, was the subject of an IA investigation for his conduct on this case. It's not even about something tangential. It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor and his, and I'll repeat it, disgusting conduct as it relates to my client and his text messages, etc.
Yep.
When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer. We've seen that happen before. The question, or questions, if I could, that surround this inquiry, and the reason that we included it in our motion to dismiss, is because it appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day, unidentified, how would this person know who the juror sitting in one of these seats was if she was at a private location? I won't mention the location. How would they know?
Good
How
point.
would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things? How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people, who was then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander.
And that jury complaints are
If he's
going
the
to
commander
him.
of all security operations, he's a commander over operations that are attendant to the courts, the actual court's security, the personnel security, the party's security, to whatever degree that is necessitated, but maybe most importantly, the jurors' security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given. But we do know this. He was this same Fanning that was just randomly picked to go report this to, was also the person that was in Ms. Reed's house seizing her phone just months before the trial, He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial. He was also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that existed. And yet, we were denied an opportunity, Your Honor, an important opportunity, to simply inquire before this juror was dismissed. That's all we asked. Let's get Lieutenant Fanning in here, let's find out what the source of this is, and let's figure out, is it even remotely true? Remember, the juror never said it was true.
Yeah.
But lo and behold, minutes before I stood up to give my summation, that juror is removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about. This is about what happened at sidebar in the matter of minutes that denied Ms. Reed her constitutional right.
It's true. It would have to be somebody in the courtroom to recognize the juror and know that it was a
I
juror.
just want to make. Mr. Brennan started his comments by talking about the sallyport video and how unimportant it is. How unimportant that video is. And I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull sallyport videos if you're investigating a bar fight. This was the purported murder weapon.
Yeah. Chain of custody.
Is the thing that the Commonwealth suggests
That they never once documented its condition.
was used to kill a cop.
And so material that they
Video
knew
that
within
you pulled into
days to go
sallyport
ask
might
for
be
it.
of some evidentiary value? I don't know. Can't imagine why that would be important. Can't imagine why that might have some evidentiary materiality. But I do know this. I do know this much. One guy who thought it was important.
He's pissed.
The lead investigator. He pulled it all. All of it. He was super convinced it was important. And he's the guy that once pulled it, hid it from us for nearly 3 years. Mr. Brennan spent some time talking about the difference between cracked and missing. Interesting point. Now, I'm not going to go through a bunch of videos and audios, but the court has seen all the pictures and photographs that it needs to see, and the court has a very good memory.
No, show them the reconstructed taillight. We're going to look at it. We're going to look at it, guys.
Ever disputed that the light was cracked 5:07 or so a.m. That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces
Yes.
that were purportedly found, well, they were found at or near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety. Almost. Except a piece was still missing.
Thank you, Alan.
There's a big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant. And it's exculpatory. The condition of that light when it pulled into the sallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Buchanan, in front of a jury, present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page in sight now. I remember it because I was sitting there. He asked the question, did you see Mr. Proctor? It was something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Cooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played, is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes, I'd like a copy of
I
that.
don't think I have. Sure. We can get that for the court immediately. Also, he played a video of the grainy video, showing, hey, look, some of these cameras are just grainy in other particulars as well at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, my memory serves me, and it's my memory, and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers, was at the bottom. Yet the video he just played is at the top. That's the exact same video. If it's apples and apples, oranges and oranges. Why is that different? That's interesting. And with regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, piece is missing. It's completely consistent with the condition of that taillight before it was at the sallyport. With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, why is the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot,
Come on, Court TV, get with it. Hello. Let me see if we got law and crime. Looks like Law and Crime has lost the signal too. Don't know what's happening, guys. Looks like they lost the stream. Yeah, that's exactly why we need an evidentiary hearing. Or he should have put it in an affidavit. That's exactly why. Because there's no basis. There's just a prosecutor making assertions. We got great case law in Washington about that, about how prosecutors' assertions are just that, and they are not evidence, and they have no evidentiary value. And so you can't rely on them for any kind of evidentiary value. It's such a commonplace thing. I mean, the jury is literally instructed in their instructions. The attorney's statements are a mere argument. You don't take them as statements of fact. And yet here we are. And yet here we are with the prosecutor's argument, kind of confusing what's fact and what isn't. Well, while we're waiting, why don't we just go ahead? Let me find that taillight photo. Because, yeah, that's kind of important. Kind of important. That's the reconstructed taillight. And that whole big section was missing after they went back and got all of the red. Yeah. Yep. That's the reconstructed taillight. All right, I'm hearing Channel 5 might be able to have the stream for us. Okay, so let me go ahead and get us back to where we left off. And then I'll go ahead and share that one. Oof. Okay, stop that, Court TV. Stop that. Thank you very much.
Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about?
This is roughly where we were.
This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot, it's irremediable harm. Irremediable harm. This case should be dismissed because of the conduct of the Commonwealth, including Michael Proctor holding onto those videos, hiding those videos, and then others involved with strategizing how to use the videos against us, against the defense, in a murder trial without our knowledge and without giving us the videos. But if the court, in the face of all this, determines that it's either unconvinced at this juncture to dismiss this case, then we urge the court to have an evidentiary hearing. That's what this demands, at the very least. An evidentiary hearing so that the court can perfect the record. We shouldn't be guessing at things. And I'll submit.
Any follow-up, Mr. Brennan?
No, thank you.
Ms. Giannetti, do you want to say something?
I don't think I need to in light of that presentation, Your Honor.
All right. I know you want to do your motion, Mr. Alessi. I cannot imagine that you can summarize it all in 10 minutes, can you?
I cannot, Your Honor.
Okay. So I'm not going to have anybody back here this week or next week. We'll hear that on the 18th when we hear everything else. I urge you, Mr. Alessi, to condense it as much as possible, okay?
I will.
I mean, your pleadings are very thorough.
I will do so, Your Honor.
Okay. Not yet. So I gave the parties until, instead of Friday for all the motions in limine, next Monday is fine, but by the following Friday, I want any responses, oppositions, any responses to the other side's motions. And then we'll have a hearing on the 18th. Jim, did we put aside any other days as well?
We did, I thought.
There's that deep sigh. We've been waiting for that.
Just a sec.
Yeah, we did 18 and 19.
That's what I had, yeah.
All right. I would expect that we would finish all the motions in limine in 2 days and wrap up whatever we have here. All right. All right. Yes.
Fox 25 produced the materials at the beginning, like March 1st. I went down to see if I could get a copy. It's on a hard drive. I can't simply look at it in the clerk's office. I would like permission from the parties to be able to take a copy of the hard drive, or if I can get the hard drive and make a copy and return it.
Does the defense want a copy as well?
Yes, Your Honor.
All right, so you can make copies.
I'll make 2 copies, and then I'll return the originals to the court.
Okay. All right.
Just before you leave the bench, Judge, I do not want the court to decide that motion for sanctions until I just supplement the record. I could do it in 3 minutes, and if
Go
you
ahead.
don't, you can cut me off.
Go ahead.
Thank you.
Go ahead.
Just briefly, Judge. Yesterday, Mr. Brennan represented to this court that I had made an extrajudicial statement regarding Mr. Morrissey.
Thank you.
And the federal investigation. You'll recall that I stood up in rebuttal and said that it was in court advocating for my client. He then said court TV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a court TV site on that. Is
Right.
there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yannetti is referring to that comment that was a court comment. And so I intend on
Correcting?
that record. There was also a conversation after with court TV.
All right, so provide it to Mr. Yannetti. Mr. Yannetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me
Well,
what you
it's
want to tell
just
me
that
now.
right now it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it, and he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, excuse me, where I was arguing before Your Honor. You know, I would just note, Your Honor, you know, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable. But, you know, it's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds, that...
You can take your time, Mr. Yannetti. You're not going to be
well, we're all
35 minutes.
Right. I certainly will not be. You know, this new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one. But I think perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team.
Yes, same
I
standard.
certainly do. So, Mr. Brennan, if you do not have a site, then I need you to let us all know that as well.
I will. It's convenient to retort that there were 10 lies by the court that Mr. Alessi lined up. In fact, I looked at the transcripts, some of his suggestions that I didn't read the paperwork properly, which is wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related Mr. Yannetti's remarks, it wasn't in relation to 3.6, it was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide...
Or your request for the gag order? In support of your argument for the gag order?
Response to how they had used federal materials that were under seal that couldn't be rebutted to make suggestions. It directly related to that point, not 3.6. But I will provide the videos. Mr. Yannetti is right that the exact statement that I used was from a court hearing, but then there were subsequent statements made. So my regrets to Attorney Yannetti, but it wasn't in fact...
My regrets, that's your apologies. My regrets, but...
It was to show how they've used these federal materials before the case was closed to their advantage.
All right, so if you have the site, I'll give you until tomorrow afternoon to find the court TV site.
Very well.
If you have it, supply it to all, Mr. Yannetti. So I'm ordering the Commonwealth, if they have that court TV site, to provide it to all of us. And if you don't, provide that as well. Provide that information.
Appreciate it. Thank you.
Thank you. All right, that's it for today.
All right, so court, please.
Weak sauce. I'm glad they got that on the record. I am definitely glad that they got that in the record because, yes, they do need to be held to the same standard, and that needs to be repeated apparently over and over and over again because we all see that that's not what's happening. We all see that's not what's happening. She's not sua sponte going in here and berating Mr. Brennan for all of his misrepresentations, even after nearly a dozen are detailed in the argument that Mr. Alessi made. So we can all clearly see that there's no standard. And what's her response here? Oh, you should correct it. We'll give you a chance to correct it. Not, you should have verified it in the first place before you put it out there, which she seems to be saying is the standard for the defense. What's your good faith basis for that? What's your good faith basis for that, Mr. Brennan? For that representation that Mr. Yannetti gave an interview to Court TV and made these accusations? Oh, no, actually, you were just talking without verifying your information. Isn't that what happened? Yeah, it is. And you weren't careful with your representations of fact to the court. And a court that was even-handed in applying the same standard to both sides would now find that your representations of fact are unreliable. They're unreliable. So unless you got an affidavit, something to substantiate what you represent, shouldn't credit it. Is that what we think's going to happen here? Do we think that's going to happen here? How long have we been? How long have we been with this case and seen all that? Oh, man. Well, what did we get here? We got back with Alan Jackson. He did have some time, I think, to think about points that he wanted to touch on a little bit more. And that was good because, yeah, he pointed out somebody had to be lying about not having it and not knowing because so many people knew that it existed. And so if Mr. Lally did, in fact, make an inquiry and they really didn't know, Lally's either lying about making the inquiry or somebody is lying to him about what they have and about what's available. So, oh man. You notice how Brennan never really answered the main question, the thing she told him to direct his comments toward, and then, you know, does she redirect him? Does she follow up? Does she point out that he's not actually answering the question? No, what he does is he tells a very unchronological story about how all this happened. A very unchronological story. And I mean, the key question here, the whole problem is that more and more information keeps trickling out and it keeps expanding what was done and when it was done and how it was done and who did it. And so I'm just still not clear on how, if Proctor is going back to Sergeant D. Petro in June of 2023 to ask for more video, how he's able to get that video if it's on a 30-day overwrite. It couldn't have been on a 30-day overwrite. So when did the 30-day overwrite start? Big question I have. Now, apparently, there's additional hard drives. It's not all just stored on the DVR, it's stored on additional hard drives. Where and when and for how long? And do those have an overwrite? And when did that start? There seems to be a conflict between what Mr. Jackson told us is in Sergeant D. Petro's new report about what he was asked to do and when, and the way that Mr. Brennan is representing it to the court, because sounded pretty clear that what Mr. DiGiampetro said in his report he downloaded the video in 2023, in June of 2023, for the entire time frame that the SUV was in the Canton Police Department sallyport. The entire time frame. It was so big it had to be broken down into 6-hour chunks that this was all of the video. So yeah, how is that possible if it should have been overwritten sometime in early March of 2022? How did he have access to it? No explanation for any of that. So yeah, either someone saved the entire thing, all of the video, so that they can go back and then selectively access and produce the pieces that they want to, or it wasn't on the 30-day override at the time, and that happened sometime after. And if that happened sometime after, when and who and why is kind of important. Kind of important. They downloaded additional videos in the spring of 2024, according to DiGiampetro. He's talking with Rafferty, and he downloaded all the videos you and I thought would be needed to refute defendant's claims. Where did you get those? Now there's more. This is where they're getting the hallway and stuff. That's not on a 30-day override? Where'd you get that from 2 years after the fact with a 30-day override? Yeah, they had to have had it all. They've kept it all somewhere in some format. And why am I guessing that all of it still has not been produced to the defense? We know that all they just got in this latest production, they told us yesterday, according to Ms. Little, it's the same stuff. Same stuff they've already produced. So where's the source? Where's the entire the entire video collection that they've been able to go back repeatedly more than 30 days later, download from and produce? That's the question that needs to be answered, that would explain the drips and drabs of the videos. He didn't explain anything about the drips and drabs of the videos. He just laid out a timeline. Timeline is not explanatory. It's just what is. Okay? The question here is, why and how did that happen? And he never answered that, and she never pushed him on it, did she? Never pushed him on it. No clarifying questions. So, what video was available when? How many cameras are there? What do they record to? Is all of that on a 30-day override? How did then subsequent videos come into the Commonwealth's possession more than 2 years later? Remarkable lack of curiosity on the part of the judge. Yeah, the fact that they're strategizing over these videos, that is a real problem. They're specifically going through and selecting things to try to respond to defense arguments. You know, if the defense has to turn over their rebuttal evidence, doesn't the Commonwealth also? Wouldn't that be what applying the same standard to both sides look like? They know that it's material. That's why they kept all of it. That's why they're going through all of it. Sergeant Buchanan does this new report about events 3 years ago. A new report where he's the mule. Now he's the mule. Convenient. He picks it up and gives it to Proctor and has no idea what it is. Didn't look at it. Won't be able to say if there was any kind of modification or so forth. Mr. Brennan asserting as a fact that the video hasn't been modified, hasn't been altered. Baseless. Baseless. Because it's because of the Commonwealth's actions that we're not in any position to know. Because we can't look at the source material. We can't look at the metadata. We can't see if it hashes to the extraction. We can't do any of that. Because of the Commonwealth's actions. So, yeah, no, we absolutely don't know that none of this has been altered. Oh, I can't wait for them to go over with a fine-tooth comb the video that we watched today that Mr. Brennan put up on the screen for us, and the videos that have already been produced, the videos that were played in the last trial. He says he thinks he remembers that the Chiron is in a different location. I thought I remembered that the Chiron was reversed, but maybe it wasn't. I saw some comments flying through the chat that the Chirons are different colors. They're going to go through all those details. Any little discrepancy between those videos, and we're going to have a little bit of a stronger argument that kind of looks like there might be some alteration here. And maybe that's why the Commonwealth didn't want to produce any of this. Maybe that's why we have this remarkable coincidence of how bad all the cameras are at just the moment when it would provide the one piece of evidence that would really substantiate, undermine the defense's whole claim that the condition of the tail light at the time the CERT was recovering these tail light pieces was the same as it was when it came into the possession of old Michael Proctor. We looked at the reconstructed tail light. Yeah, there's a bunch of pieces there they never found. And isn't it bizarre? Isn't it bizarre? I'm going to pull it back up because, I think this is kind of important. We are to believe that the Commonwealth recovered 47 separate pieces of taillight and was able to reconstruct them all into this casing. All of these pieces of taillight, they would have been just randomly distributed around the lawn, right? It would have been shattered. There's been snowplow activity going through. There's been shoveling and walking and parking and all of that type of thing. And yet, despite this random distribution and collection of these pieces, the only ones that just happen to go up not missing are all in the same area of the taillight. Those are the only ones they didn't find. That seems like quite a coincidence. Really seems like quite a coincidence to me. just all happen to be right in the same area. Those are the ones that got picked up by the snowplow or what? Or what? What else? What else happened to them? Where did they go? It's quite a remarkable coincidence, isn't it? So ultimately, at the end of the day here, I don't know that we've gotten a whole lot further than where we started, because I think the bottom line is still really the same. If she doesn't want to have an evidentiary hearing, then she's going to have to find some basis as a matter of law that this either isn't Brady, you know, it doesn't satisfy the Brady requirements, it's not exculpatory, it's not material, or, you know, that it's even though it seems to be pretty plainly misconduct, it doesn't warrant a sanction. It doesn't warrant that egregious a sanction. Hard to do if you have to take the allegations in the light that the defense is arguing them, taking their facts as true, because otherwise you got to resolve factual disputes and you need an evidentiary hearing to be able to do that. I wanted to pull up to, I went looking for this while the argument was going on, because I know they did cite this in their memorandum, but it's kind of important. This is Kyles versus Whitley. This is a withholding of evidence case involving Brady. And it's important because it really spells out a little bit more clearly what this standard is of materiality, right? Is it exculpatory is really easy. Does it help the defense make an argument? And there's no question here that at the bare minimum, this is impeachment evidence. At a bare minimum, it's impeachment evidence. And I think Ellen Jackson made a great argument that, yeah, it helps the defense case by showing this is all very sus. And so we get to argue it's all very sus for a reason, because that wasn't the condition of the taillight when it got to the sallyport, and they're trying to conceal that. So materiality, I think, is where it comes down to. And that's, I think, when she's saying prejudice, that's what she's talking about. She's talking about the materiality standard under Brady. It's similar to the prejudice standard that you might have for like an ineffective assistance of counsel type of argument, but it's not the same thing. And that's what Kyles versus Whitley makes really clear here. So they say 4 aspects of materiality under Bagley bear emphasis. Although the constitutional duty is triggered by the potential impact of favorable but undisclosed evidence, a showing of materiality does not require demonstration by a preponderance of the evidence that disclosure of the suppressed evidence would have resulted ultimately in the defendant's acquittal, whether based on the presence of reasonable doubt or acceptance of an explanation for the crime that does not inculpate the defendant. This is very different from the run-of-the-mill prejudice standard that you're dealing with most types of constitutional errors, where you do have to show reasonable likelihood that the outcome was affected. This is not that. They don't have to show more likely than not that she would have been acquitted if they'd had these videos. It's explicit right here. That's not the standard. Bagley's touchstone of materiality is a reasonable probability of a different result, and the adjective is important. The question is not whether the defendant would more likely than not have received a different verdict with the evidence, but whether in its absence he received a fair trial, understood as a trial resulting in a verdict worthy of confidence. We can trust that this was a fair result because we can trust that it was a fair process. That's the question. A reasonable probability of a different result is accordingly shown when the government's evidentiary suppression undermines confidence in the outcome of the trial. If this evidence tends to tip the scale in favor of dirty cops, does that have a reasonable possibility of affecting the outcome? Yeah, it kind of does, because that really tilts the scale in favor of the defense theory here. And in light of all the other problems that we have with the Commonwealth case, including, I don't know, the pretty much total failure to prove that John O'Keefe was ever even hit with a car. That real fundamental foundational fact that they had a real hard time with. Proving that he was ever even hit with a car. Their own medical examiner wasn't even going to go that far. It's very unconventional. Unconventional injuries from a motor vehicle collision. The second aspect of Bagley materiality bearing emphasis here is that it is not a sufficiency of evidence test. A defendant need not demonstrate that after discounting the inculpatory evidence in light of the undisclosed evidence, there would not have been enough left to convict. The possibility of an acquittal on a criminal charge does not imply an insufficient evidentiary basis to convict. So this isn't a standard where we're going through and looking to see, well, could the jury have still believed the Commonwealth anyway? She doesn't have to disprove the Commonwealth's case in order to show this evidence is material under Brady. She doesn't have to do that. One does not show a Brady violation by demonstrating that some of the inculpatory evidence should have been excluded, but by showing that the favorable evidence could reasonably be taken to put the whole case in such a different light as to undermine confidence in the verdict. The shady cops. What they could have done, what they should have done, and why were they scurrying to hide this information? Why is the video behaving the way it is, coincidentally, right at the time when it would show what needs to be shown to evaluate if the cops are dirty or not? Does that put the case in a little bit of a different light? Pretty strong inference. Third, we note that contrary to the assumption made by the Court of Appeals, once a reviewing court applying Bagley has found constitutional error, there is no need for further harmless error review. So we don't go through, we don't do this prejudice analysis like Judge Cannone is kind of suggesting. You're just looking at materiality. If you find it's material, you're done, because the material standard is what incorporates the reasonable probability that had the evidence been disclosed, the result of the proceeding would have been different. It's just a reasonable probability. That's it. So then, there's some kind of explication of the, legal standards and stuff like that. But they're pointing out specifically why it's different in the Strickland standpoint than it is under Brady. And so the fourth and final aspect of Bagley materiality to be stressed here is its definition in terms of suppressed evidence considered collectively, not item by item. We don't go through and say, well, this particular video wasn't a problem, or that other, because this video is grainy and blurry, it doesn't really help. It doesn't really help anybody. The issue here is the totality and the collective impact of it, and the fact that there is so much video that they had this entire time. So much that they had, that they knew that they had, that they never handed over, that they presented in this misleading fashion to the jury, and that bears all of these very sus-looking hallmarks of some type of modification, like being inverted, having minutes missing, having ghost people apparitions appearing and disappearing throughout the course of what you're watching. Oh, and by the way, they also didn't preserve any of the metadata. The investigators who were responsible for the evidence preservation, they didn't preserve what is necessary to prove that this video is authentic. They're the ones who are expected to know that and to do that, and yet they didn't do that here. It's the totality of the circumstances of all of that. That's how you determine materiality, not just going through and saying, well, this particular video wasn't helpful. This other particular video wasn't helpful. As Justice Blackmun emphasized in the portion of his opinion written for the court, the Constitution is not violated every time the government fails or chooses not to disclose evidence that might prove helpful to the defense. We've never held that the Constitution demands an open file policy, however such a policy might work out in practice. And the rule in Bagley, Hinson and Brady, requires less of the prosecution than the ABA standards for criminal justice, which call generally for prosecutorial disclosures of any evidence intending to explicate or mitigate. So, while the definition of Bagley materiality in terms of the cumulative effect of suppression must accordingly be seen as leaving the government with a degree of discretion, it must also be understood as imposing a corresponding burden. On the one side, showing that the prosecution knew of an item of favorable evidence unknown to the defense does not amount to a Brady violation without more. But the prosecution, which alone can know what is undisclosed, must be assigned the consequent responsibility to gauge the likely net effect of all such evidence and make disclosure when the point of reasonable probability is reached. So for Mr. Brennan to be arguing, we can't anticipate whatever the defense is going to argue. Actually, you're kind of responsible for doing that. That is actually part of your responsibility. You need to bear all of that in mind, and you need to be anticipating what are the potential uses of this evidence, and in what way is it detrimental to my case? You know, spotting bad facts is basic lawyering. It's basic lawyering, and there's definitely a lot of lawyers out there that like to just pretend that those bad facts don't exist. Kind of vaguely remember we might have talked about that in trial 1. We're seeing a little bit of that with Mr. Brennan for sure. Kind of remember seeing it with Mr. Lally. There's no evidence. Absolutely no. You hear stuff like that, it's a big tell. It's telling you they're unable to steelman the defense's argument. They're not able to even really recognize the defense's argument. They have to just dismiss it and pretend it doesn't exist because that's the only way they have to deal with it. But good lawyers recognize the bad facts, and they acknowledge the bad facts, and they work around the bad facts. Because the jury isn't going to be blind to them. The jury's going to see them. So, you know, gaslighting strategy versus acknowledging reality and trying to deal with it anyway. Yeah, Bagley basically says you don't get to gaslight. You don't just get to insist, no, this doesn't exist, and if it does, it isn't important, and if it is important, it's not material, and if it's not material, you know, you don't get to do that. It's your obligation to spot how the defense might use this evidence, how it might be beneficial to their case. That responsibility is on you. So I wanted to share that. I'm also going to share real quickly, Brian Barrera, I saw was in the chat, and he sent me the link to this, the Massachusetts rules of professional conduct that specifically apply to prosecutors in Rule 3.8, because they do indeed have some specific duties, including some that are a little bit more stringent than in other jurisdictions. And so, you know, right here, make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. and in connection with sentencing, disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor, except when they're relieved of that responsibility. So, yeah, you gotta timely disclose stuff, and not just the stuff that tends to negate guilt, but stuff that tends to mitigate, stuff that would tend to make it perhaps not as bad, even if it actually did happen. All these statements about extrajudicial, rules about extrajudicial statements, not only are they not supposed to make them, but they are also supposed to take reasonable steps to prevent investigators, law enforcement personnel, employees, or other persons existing or associated with them from making these types of statements. So, you know, this goes a little bit back to old Mr. Morrissey himself, but yeah, should not be extrajudicial comments that if the prosecutor had made them, they'd be prohibited under Rule 3.6. This one right here, G. Not avoid pursuit of evidence because the prosecutor believes it will damage the prosecutor's case or aid the accused. This is the key right here. You have a duty to find it. You don't get to put your head in the sand and then say, I didn't know. You don't get to be willfully blind. You don't get to avoid your Brady obligations by not looking for it. Your obligation is to be full and fair in your investigation, to be thorough, and to ask the questions that need to be asked, whether it's going to help your case or not help your case. See any shortcomings? Any shortcomings in the prosecutorial actions in this case in light of these standards that apply to them? Since ethics are kind of the topic of the last couple days, last couple hearings, question about standards and what standards apply to who. All right, guys, we got a fair number of comments to get through, so let's go ahead and start with that. First off, with Melissa gifting some more Andrea Burkhart memberships. Melissa, you are so generous. Thank you so much for that. James Casatelli, I had a cat named Buffy. Great minds think alike. It's a great name. Do I want to tell you the long story about why the dog has the name Buffy? Everybody assumes it's Buffy the Vampire Slayer. It's not Buffy the Vampire Slayer. In fact, I've never even watched Buffy the Vampire Slayer, which I've heard good things about. Maybe I will someday, but I never did. I wasn't a fan. The reason my dog is named Buffy is because the breeder for that I got all of our dogs from, her tradition is that each litter will have a theme, and so you choose the name for the dog, but you choose it in accordance with the theme. And of course, these are purebred dogs. These are show dogs. So they have a paper name, a very fancy paper name, and then their regular name. So the theme for Buffy's litter was a dessert. It was a dessert theme. So name the dog something related to dessert. And so the name I gave Buffy that is on her papers is It's Pie O'Clock Somewhere. That's her formal dog name. It's Pie O'Clock Somewhere. And, that's a song that Alan Jackson and Jimmy Buffett sang. It's 5 o'clock somewhere. It's a play on that. So Buffy is the short for Jimmy Buffett. That's why her shorthand name is Buffy. Anyway, long story for how I got to that name. Don't even ask me how I named Rupert. It's even more complicated. Amara Deshane, Chilean sea bass is so good too. Yeah, Chilean sea bass is fantastic. Wonderful, wonderful fish. There's a fish that they eat a lot. It's very, very commonplace in Chile. I'm not actually sure how to pronounce it, if it's hake or if it's hake. Is how we say it in the West, but down in Chile, they call it merluza, and it's very similar to like a cod or maybe like a sea bass. It's another just slightly sweet, firm, delicious white fish. Oh, so many good fishes down there in Chile. James Casatelli, it feels like most of these issues stem from Bev's inability to keep her mouth shut. She has to be handing them wins on every appeal. No, I went through Bev's appeal record, some while back. It's not great, man. It's not great. She gets reversed a lot. She does seem a little bit just impulsive, is part of it. But also, she just, is it that she can't keep her mouth shut, or just she tries to go, she knows where she wants to go. Like, that's the thing. It's telling how she interrupts and the questions that she asks and stuff. This whole initial sort of interrogation of Mr. Jackson, she clearly wants to reach the outcome of, you didn't have a basis to make this claim in your statement, and he's got an answer for everything that she has. So she isn't able to get there. But, am I to believe that it's still not in her mind right now as we sit here after having had this entire hearing, that she still wants to reach the conclusion that he didn't have a good faith basis to make that statement, or that he did something, that warrants his removal from the case? No, I think that she still probably does. And so it's just the fact that she seems to be a little bit outcome driven in her reasoning, which is not particularly uncommon for judges. It's another one of the dirty secrets. We'd like to think, they just impartially, objectively look at all the facts, objectively analyze the law, and put those two things together, and then just get the conclusion that inevitably follows from doing that. The problem is that there's law on pretty much any topic that you can find to support pretty much any issue. It can depend, you can choose how you frame the issue as a judge in order to make it fit, to get the best law that applies for the situation that you're trying to address. So it's very, very common. You already know what outcome you want to reach, and you're just looking for reasons to be able to justify it. That's where I think the mistakes get made, because then you do end up with a big blind spots because you're not objective. It's just like the Commonwealth not being able to steelman the defense argument. The judge isn't potentially able to do that either. It's so unpersuasive to them that they can't consider it fairly. And so if you can't consider it fairly, that's where you risk making a mistake. That Southern blonde lawyer, Bev is making this so personal that it's extremely uncomfortable. We must ask why. Until today and her telling him to move on, I naively haven't believed she was personally involved in the corruption. My mind has changed. Well, I know that there's a lot of people that have already taken that step. I'm not prepared to go there yet myself. I'm really not. And just the main reason why is because I still don't see anything that I don't think can be adequately explained by the idea that she's just adamant that the Commonwealth and the law enforcement are the good guys, that they have the white hats. And since they wear the white hats, then what they do must be good. And, therefore, even if they're doing things that are ostensibly bad, it's either excusable, like with the texts, the Michael Proctor texts, or it's, not just not really that bad, or it's for a good reason, the ends justify the means kind of rationale. So I'm still just in the bias side. I think she just has a very strong bias in favor of the Commonwealth and the law enforcement, a strong bias against the accused. Again, it's just unfortunate to see it from a public defender, former public defender. But I also do kind of understand, I've mentioned before, when you're a public defender and you're in the trenches and you're dealing with just the volume, the everyday flood of criminal cases, the completely mundane stuff that never ends up even in the newspaper, let alone, you know, being televised on court TV. It's just a massive, massive flood of cases and accusations and evidence and police reports and stuff like that. And the reality is that most of the time, not that many of the accused are legitimately factually innocent. You know, it doesn't happen that often. Now, there's a lot of gray area where often the accused is maybe not guilty of exactly what they're being accused of. You know, the charges are being, what's the word I'm looking for? You know, they're just filing a much harsher thing than perhaps the evidence, really supports. They're going in and taking marginal bits. Like a common example that I see is certain ways that assaults can be elevated into felonies, where it's just like it's a routine assault, misdemeanor, not a good thing, of course, shouldn't happen. But, you know, there will be some little fact that can escalate it to a felony, and the evidence for that is like really chippy or really thin. But, you know, they charge them with the felony because the jeopardy is severe, and so it gives them a lot more leverage to be able to negotiate some kind of resolution. So that's really where so much of the defense work takes place, is in working around those margins, around the gray area. It's not that people are actually innocent. It's that they're not being fairly treated. So I think there is a possibility that the public defender, they can get jaded by that. You know, they could look at that and think, well, most of my clients were guilty, so, you know, this one probably is too, that type of thing. And that's just not the attitude that you should have certainly not when you're sitting on the bench. It's really not the attitude that you should have. So that's kind of where I'm at with her. I think she's just biased, but I understand very much why people are thinking this has got to go more. I mean, to the extent that it's personal, I do think when they're getting into the jury, you know, the dismissal of the juror, and she's kind of injecting herself as well in this whole process about the court officer and you know, fanning and I told you and stuff like that. That does make it more personal, you know, if she's like a witness to it. She's had her decisions challenged, you know, over and over now. Puts her in the hot seat. You know, this goes up to the Court of Appeals. There's a risk that she's going to look bad if the Court of Appeals agrees with Karen that this juror should not have been dismissed. There was not an adequate record of good cause for the dismissal. Really doesn't sound like there was. This really sounds like a potential problem. So if she knows that, especially if there's that consciousness of I, you know, might have done something wrong here, well, you know, that's part of why it would look personal. You know, you'd be a little bit touchy about that. So that's where I'm with it at this point. Phil the Gilbert villain Biggs. Is Judge Cannone skating close to the edge of impropriety, inserting biased emotion arbitrarily from the bench, judicial authority notwithstanding? You know, it's a question of lay perspective versus law. You know, we can all look at it with our own eyes and make our own determinations about that. I've made no bones about the fact that when I look at this judge's demeanor in the court, I see very different treatment of the defense than the Commonwealth. And we've given lots of examples of that. And I'm not the only one that sees it that way. Now, is this going to meet a legal standard to establish bias? Probably not. Almost probably not. The standard to show a biased judge when it comes to disparate treatment of the parties is the bar is so high. The bar is so high. I mean, it usually requires some kind of like abusive behavior, you know. Are we getting close to it with the sort of one-sided allegations of misconduct for activity that in the best light seems to be occurring pretty much on, you know, both sides to the same degree? Best case scenario? I mean, I don't think we're going to be at that bar. I really don't. It's extremely, extremely hard to do. And, you know, barring them coming out and saying something explicit, like, you know, I'm not going to believe you because you're the defendant, you know, whatever, something like that. Extremely, extremely hard to show bias. So, you know, from our perspective, is she close to that? Sure she is to mine. But is it going to be enough to get her, that in and of itself, to get her disqualified? Almost certainly not. Kevin Dorr, it looks like 2 feds sitting in O'Keefe's box. Why after investigation closed? If they are feds, they look like feds with their pins. I did see some, you know, suited looking people sitting in the box. I don't know who they are. We saw a lot of people like that in Delphi. There would be days where these mysterious suited and pinned people and stuff would show up in the courtroom. Sometimes they were feds, but also sometimes they were off-duty police, off-duty ISP, the troopers, and stuff like that. So, you know, they could be, but they could just be, you know, ordinary law enforcement, Boston police or something like that, maybe. I don't know. The pin does always kind of seem like a giveaway that it's law enforcement. I know it doesn't have to be, but why is that? Why does that shiny pin in the lapel just like always scream? Why does it always scream cop? I'm not sure. That Southern blonde lawyer, Bev. Jimmy, can you get a mop for the puddle of urine under Adam's chair? Yeah, Lally is pretty much in the hot seat, isn't he? While Mr. Jackson was making his argument there, because yeah, he is implicated now. What did he know and when did he know it? What did he review and with whom, and what did he disclose and when? Yeah, now is Bev going to require him to account? I'm skeptical, but he certainly has good reason to be nervous. Carazola X, way she acts like she cares more about lunch than what he's saying is outrageous and intentional. Women are masters of this mean girl stuff, no accident. Yeah, you know, women their power is social. It's not physical, you know, men. Biological reality time, guys. This ain't political, ain't woke, just is what it is. Overwhelmingly, men much, much physically stronger than women. It's just how it is. But women have the social power. And so, yeah, that's how they get their status and so forth. Oftentimes it's manipulation, it's games, it's, you know, gossip and things like that. So these are definitely tactics that are not unheard of. But yeah, the dismissiveness, it's lunchtime. You started an hour late. You couldn't have taken your lunch. You couldn't have taken your lunch early so we could continue this argument. You're going to cut him off midway through because lunch is really important. It definitely is very dismissive, and it sends, I mean, I agree. It sends that message that you're not important. Your argument here is not important. Yeah, it is a little catty, isn't it? Z, defense, show us numbers of jurors picked. Clerk, no. I mean, yeah, when it comes to the jury, certainly with respect to the parties, there should be absolute and total transparency. There should not be anything that they're not allowed to know about the jury, how the jury is handled, how the jury is selected, and so forth. Zeke, Texas, NP, it would be in Bev's and the Commonwealth's best interest and personal, best individual and personal interest to dismiss with prejudice and hope everyone forgets and moves on. Well, you know, I don't know how involved Bev is. Really don't. Like I said, I continue to think that this can all be explained by bias, by severe bias. But, you know, the wrongdoers know where these threads are leading. And, you know, they know what kind of risk that they're in. So yeah, I can see a good argument that now would really be the time to cut your losses and just let it go. And the advantage that they get, like I've mentioned before, I mentioned on Melanie's channel, I think I mentioned yesterday, the advantage that the Commonwealth gets from this type of outcome and dismissal with prejudice is they get to maintain that they were right all along. That this was procedural, it was a loophole, technicality, has nothing to do with whether she was guilty or innocent or not. So they get that little face-saving message, you know, that lets them continue to position themselves as the heroes, even while they, at the same time, are the people that are responsible for no justice ever for John O'Keefe. Alessi's big brain to free Karen Reed. Will you be covering the Robert Brooks case when it happens? I have not been following that case, so I'm not planning on it. The main ones that I'm following at this point, that I'm hoping to, you know, be able to track pretty closely. Obviously, Karen Reed when she goes forward in April 1st so far. Interested in Diddy. There's going to be some overlap if that one also goes forward when it's scheduled to go forward, because that's supposed to be starting like in early May. So I may not be able to follow that one super closely, and it's going to be in federal court anyway, so there's no camera. But you know, I'm very intrigued about what's going to come out in that case. Koberger, obviously set to go to trial starting July 30th is when jury selection starts. So, and that one's going to be, you know, for several months. So I don't know where Robert Brooks is going to fit into all of that. Don't know. I'm going to say offhand, I doubt I'll be covering it. But I'm not gonna commit and say no, absolutely. I don't know where it fits in schedule wise. Auto Doctor 911. Why not argue irrevocable prejudice for Higgins vid, because could have gotten phone evidence if turned over while preservation order was valid, if not already destroyed. It's possible. I don't know what the timeline of that is necessarily going to look like. Because I think the issue with Higgins is that it's not necessarily material to impeach Higgins until Higgins is on record with his events, his actions that night, and he's either not mentioning phone calls, or he is not he's denying making phone calls, or something like that. So I'm not quite sure off the top of my head where Higgins testifying at some point, you know, where he can be nailed down with a formal statement, lines up with the request for the preservation order and you know, the destruction of the phone and all that. I mean, the bottom line is obviously, of course, you know, it didn't matter. He destroyed the phone while the preservation order was pending, while the motion was pending. So it wouldn't have changed anything from that standpoint. But I think the important point here is, does it maybe shed some light on, you know, why he would have destroyed the phone? Can they still get evidence from the phone providers about who was this call from? Who was it to or from? Don't really see offhand why they can't. Why you just can't go to whoever his cell service provider was and get the number for that phone call. Seems pretty highly relevant. Seems like something that they'd have. It'd be in their records. So I do wonder if they're going to follow up on that. Oh, so many little new goodies to look forward to in this retrial. I'm telling you, it's so rare for like the defense to be in the driver's seat and on the front foot when they're coming forward to a retrial, because the opportunity to keep digging benefits them more than it benefits the prosecutor. Doesn't usually happen, but kind of seems to be the case here. John Beattybot, supplier of CPD security system, called in to shed light on video quality, metadata, tampering, forensics, etc., et al., along with archival law enforcement hold procedures. Yeah, I'd say those types of questions should be asked. It sounds like they're only just now learning that maybe that's the, what was his name? Louis, I can't remember his last name now. Jutro or something like that. Sounds like maybe that's his purview. Yeah, I think that's reasonable. And like I was saying before, the follow-up on the overwrite. When, who, why, how, the additional storage that it now sounds like, you know, is suggesting that existed. Who, what, when, where, why, how. The replacement of the one camera, the inverted video camera. Who, what, when, where, why, how? Where's the records? Okay, we know that he, the Louis guy, he's the one that did it. Jutros, is that? I can't remember now. It is what it is. It was a strange name. He's the one that replaced the camera. Who told him to do it? You know, perfectly good starting point. Yes, I want to see these threads continue to be pulled. That's how you unravel a cover-up, is you just continue pulling on the threads. So yeah, I'd love to see stuff like that. Phil the Gilbert Villain Biggs. This trial is dripping with impropriety from GO, more apparent every day. I refuse to believe the feds are done with DA Morrissey, MPD, CPD at all. It's more secondhand information, isn't it? It's not from the horse's mouth. It isn't from the horse's mouth. And, you know, you can, I think, make what you want of that. Am I obligated to believe that that the investigation is over because Hank Brennan and Helena Rafferty say so? I don't think so. I think we kind of got some credibility issues with both of those two as far as I'm concerned. Kind of got some credibility issues. And just, you know, a lot of contextual kinds of issues that raise questions for me. I'm not saying it isn't. I don't know. I think that's the whole point. I don't know. And that doesn't convince me. So yeah, it does. There's just so much in terms of the shenanigans. But I think the issue there is, like I mentioned yesterday, it's a challenge to hook that in with a federal crime. To hook it in with a federal crime, because typically to prove corruption, you're having to prove some type of specific benefit that is flowing to that officer. And when your entire system is corrupt, when I don't have an expectation of something specific. I just have a general expectation that when it's my turn for somebody to have my back, they will. It's hard to pin down and establish a federal crime in that kind of context. So, Michael Muddragon, I've dubbed him Sergeant Dijon Petrol, aka Sergeant Mustard Gas. That's great. Super chatting so Andrea sees it. I like it. Dijon Petrol, Mustard Gas. Yeah, I have an easier time with the Italian names are not that hard for me. Dijon Petro. But Jutros or whatever it was, that one, it's different. It's not, I didn't get Italian from that one. I don't know. I'm sure it's in my notes. It's in my notes somewhere, but Jutros. Jutros is what I wrote down. Hopefully that's right. Dijon Petrol. That's very clever. Greg, goodness, everyone on her team really knows how to command a room. They do. They know how to turn it on when it's time to turn it on. And they know how to get your attention. They really do. They know how to get your attention and let you know it's time to listen now. It can be very, very difficult with a 1 hour, 2 hour, 3 hour type of presentation. Very difficult to follow. You know, it's just normal. Your attention is going to wander. Some parts of it are going to be high points. Some points of it are going to be low points. So knowing when to have that modulation and to turn it up so that you know right now Okay, that stuff 5 minutes ago maybe wasn't absolutely critical for you to hear, although it would have been nice if you listened because I did say it for a reason and it was for a point. But this right here, right now, this is what you need to hear. It's a very good trial skill. Nikki, would it be improper for AJ to mention all of the other instances of allegations against Proctor during this argument? Missing ring footage, bad texts, etc. No, I don't think that's out of place at all. And obviously, he did. He brought up those text messages. The missing ring video, that's a good one, and that's another is that a potential missed opportunity? Because it adds to the argument for prejudice, right? That this whole totality of the circumstances, this evidence that's been suppressed, it makes the whole thing look sus. And we already know there's reason to think that this guy is sus, but now we have even more because he's specifically going and getting this video and then suppressing it. This video that we find out now years later shows him apparating in and out of the area of the right rear taillight of her video in the time frame where somebody who was wanting to get right over to 34 Fairview before starts searching and drop some pieces of taillight over there. It'd be right in that time frame. So, I mean, yeah, no, I don't think that's improper at all because it goes to the total effect. It goes to the defense theory, and how this evidence would have related to that and the potential weight it would have added to that theory. V. Grave, no wonder the Commonwealth got a special defense attorney, Brennan. They needed someone to defend their crimes, not to prosecute this case. I mean, this case from day one has been prosecuted like a defense, hasn't it? When we watched the first trial, and I kept going, when are we going to get to the part where we're proving that John O'Keefe was hit with a car? Why are we disproving whether or not Jen McCabe Google searched Hoslong to die in the cold at 2:27 a.m. before we have even established that really foundational fact of John O'Keefe being hit by a car? So in many respects, yeah, this is more of the same. But yeah, it's possible that the stakes are higher now because they know they had to show their cards during that first trial. And so because of that, now the defense knows where to push and they know where to follow and they know where the weaknesses are and they're exploiting those now. And it's very, very uncomfortable for the Commonwealth to be having these threads unraveled. So yeah, I mean, that's an explanation. And in light of what we just went through today with Mr. Lally being on the hot seat and potentially being implicated in some of the misconduct, yeah, that can be an issue too. That could be an issue too. They got to try to clean up the team if they know there's stuff out there that could dirty them. Michael Muddragon, new band name, Mike Proctor and the Buchanics. It's not bad. Not bad. Sounds like they'd be like an old rockabilly kind of band or something like that. Mike and the Buchanics. Zeke, Texas NP, Proctor is the Commonwealth. Yes, he is. I'm not a lawyer, yet I understand this fundamental concept. The they knew but we didn't excuse doesn't fly. It doesn't even come close to flying. And so it's a bit, I guess, strange to read that in the response because of how irrelevant and immaterial it is. It doesn't matter. They're agents. They are teammates. The investigating officer gets that special exemption from the rule of seclusion, right? To the rule of you don't get to be in the courtroom while the other witnesses are testifying. Now, granted, they didn't use Proctor. Nobody wanted Mr. Proctor in there, with the jury to stare at him the whole time. Once we had that opening statement and we got those details about some of those texts, can you imagine if Trooper Proctor was sitting in there at the Commonwealth's table and was there for them to eyeball the entire time? No. So they didn't do that in this particular case, but they do have the right to do that. And that's exactly why, because they act in concert. The prosecutor will often guide the investigator. The investigator will, report back to the prosecutor. Just when a charge is filed, it does not mean the investigation stops. Doesn't mean the investigation stops. So there's just continuing interaction a lot of the times throughout the course of the case. So no, it's not an excuse at all. It doesn't change the Brady standpoint. The law on that is crystal clear. And if they're trying to suggest that, well, the Commonwealth isn't the bad guy here, so you shouldn't penalize the Commonwealth, it doesn't matter. The law enforcement, the chief investigator, if he's a bad guy and if he acts with bad faith, that's just as bad. That's just as warranting a severe sanction as if the prosecutor did it. So I don't know if they're just angling to try to save face, like in a ruling or something like that. It won't surprise me at all if whatever Judge Bev decides, when we get a written ruling from her, if it's got some commentary in it about how the Commonwealth didn't do anything in bad faith, something like that. Maybe that's all they're angling for. I don't know. But yes, from a legal standpoint, it doesn't matter at all. Mispronounced name. I counted 9 confessions, 0 interruptions. No interruptions from the judge when it came to Mr. Brennan, and yet also no follow-up when he didn't actually answer the question she'd asked in the first place. So explain these drips and drabs to me. He really didn't do that. Just more obfuscation, more speaking to conceal rather than speaking to enlighten us all. Mispronounced name. Correction, 11 confessions. I'd love to get your list. I'd like to see everything that he confessed to. Just all of the different productions, the April, the June, the Proctor the first time, the Proctor the second time, the DJ and Petro, the Rafferty. Yeah, a lot of admissions in that presentation about things that shouldn't have happened, about misconduct. Michael Muddragon. Fact, bears eat beets. I bet black bears do. I don't know. Do brown bears eat beets? Are they that omnivorous? They might. I'm not totally sure. And a polar bear probably wouldn't eat beets. But I don't know. I can't say for a fact that a polar bear doesn't eat beets. I don't know. Michael Muddragon. AJ should refer to Fanning as his client while motioning to Brennan. Yeah, that would be improper. And unfortunately, we know that the rules will not be evenly applied when it comes to that kind of thing. But, it would be funny if there was an accidental slip and then a correction. Oh, I'm sorry. Did I say his client? I meant his whatever. His officer. That Southern blonde lawyer. Stream down equals major blue balls for us court junkies. I know, it's like a moment of panic. What do you do when the stream goes down? Panic. What am I supposed to do? I got to know how the hearing ends. Yeah, it is very unsatisfying. Thank you to Channel 5 for being able to pick that up and give us something to run with. Carazola X. The reason Karen Reed called for a lawyer that night was because at that time she thought John O'Keefe was leaving her, worried about how John O'Keefe and cops could get her on DUI. Well, she didn't call the lawyer that night, right? She called her mom or her dad. She called her parents that night. It wasn't until the following day is when she called Mr. Yannetti, and I forget the exact time frame now. Of course, I've got all my notes from the last trial, but I don't remember specifically if it was before. If I remember correctly, it was Trooper Buchanan had contacted her, wanting to interview her. She's out in Dighton. I'm pretty sure that's when she contacted Mr. Yannetti, but I just don't remember for 100% sure if that's the exact time frame. But it was after John was discovered, and they already knew that he was dead. So to me, I mean, nothing at all problematic about wanting to talk to a lawyer in a situation like this. You might have been the last person to see him alive. You had those text mess or those voice messages that you left where he was very angry. You know that at the very least you're kind of a witness because he never came home. He was supposed to come home. To me, it's not at all strange that you might want some legal guidance navigating that situation, whether you did something wrong or not. It's just the prudent thing to do. Because, it's one of the biggest mistakes that people make when they deal with law enforcement is they assume just because I'm innocent, then that means I'll be vindicated. That means, I don't have anything to worry about because obviously if law enforcement goes and does the investigation, they'll confirm that I'm innocent. And that's how you get false confessions and things like that happening, because people put a lot of faith in law enforcement to get the right result. But that's not the smart approach, because unfortunately, people do get framed and people do get... They become the target. They come under suspicion for whatever reason, and then the police get tunnel vision and they decide they're going to nail you no matter what. It definitely happens. So even if you're innocent, guys, don't let that make you think, well, therefore it's fine if I talk to police because they'll see I'm telling the truth and I'm the good guy and they'll corroborate my information and so forth. No, they might not. They might decide you're a convenient target. They might decide you seem suspicious for some reason. They don't really like you. Whatever. And your innocence is not going to be a shield because they may not be particularly interested in your innocence. This is why you see cases where somebody comes under suspicion, and so the police grab them and interrogate them and coerce a confession out of them. And then they get the DNA evidence. And the DNA evidence does not corroborate their theory and their version of events. So what do? They shift it. The unindicted co-ejaculator theory is, I think, how Amanda Knox referred to it in her podcast, which is very, very clever. Very clever expression. Yeah, that's what they do. Like they did that with the Central Park 5, right? The DNA came back, doesn't match any one of these kids that you've gone in and interrogated and coerced these confessions from. It's somebody completely different. So you just switch your theory to say, well, there's somebody else was involved that none of them mentioned. Nobody even suggested was present. And that's the only person who left trace evidence as a result of a gang rape. Yeah, they will do that. They will work around your innocence. So don't rely on your innocence to save you with police. Even if you're innocent, well worth having a lawyer help you navigate any type of situation where you're going to need to be speaking with them. Jeffrey B., thank you for your expert commentary. Well, thank you, Jeffrey B. That's a great name. It's a name I'm particularly fond of. Susie Grossbeck, so glad you were back, Andrea. I wish I felt the same about Judge Bev. I just, maybe I am naive. I do like to give people the benefit of the doubt until I really can't help it. I got over that hurdle pretty quick with Judge Gohl, but I've said before, I said yesterday, it's just a different level that is hard to even communicate if you weren't there to experience it and see it for yourself. The malice that flowed, it was next level. It was absolutely next level. And so Judge Bev is not there. She's not even close. She may not be a very good judge, but I'm not quite at monster in human skin yet. And, you know, maybe I'll get there. I don't know. But so far, I'm just seeing a judge who is who's emotional, who is a bit rash, who's very, very strongly biased, either in favor of the Commonwealth or against the defense, or both. It doesn't really matter which is which. And that really affects her judgment and her demeanor and her temperament. I don't know where the antipathy towards Mr. Jackson started. I really don't. But it's clearly there, and it seems to be something that, you know, she's just not going to be able to put aside. She's always going to be looking at Mr. Jackson with suspicion and trying to catch him in some kind of wrongdoing because she's got it in her mind that he's that bad guy. John Beattybot, we are now past second trial discovery certification by Commonwealth. Still no complete or forensic production. And guess what? No metadata to validate, no tampering. Yeah, exactly. And I'm still unclear. If all of the video has been produced to the defense. Because it sounds like they're saying at least one camera, if not two cameras, if not all of the cameras. They downloaded everything for the entire time period that the SUV was in the sallyport. And it was so much video, they had to break it up into 6-hour chunks. I haven't heard anything about that being produced to the defense, the totality of all of that. Because the last that we heard was yesterday from Ms. Little, that the production that they got late last night at 11:30, not last night, but the night before, was the same, appeared to be the same videos that had already been produced. So it kind of seems like we're still waiting. And yeah, we got the certification. Why am I expecting? We're just gonna get the same pattern that we had in the first trial, where we're going to be continuing to get discovery throughout the course of the entire trial. Because there haven't been consequences for it. It hasn't mattered. Sarah Boone's left kidney. Do you think Brady violations should result in dismissal with prejudice and not a new trial, even in appeals? You need to learn shorthand for RA 2.0. I mean, I can see the argument for why misconduct in particular, it needs to be seriously disincentivized. And so, yeah, the problem with a new trial is just that a new trial, in a certain respect, almost encourages them to do it, because the worst case scenario is just they have to fight fair next time. You know, that's not really a strong inducement to not fight, or to actually fight fair the first time. And then when you compound that with the fact that, you know, you can count on one hand the number of times a prosecutor suffers any kind of personal consequence as a result of this kind of misconduct, the number of times they even get named. You know, I remember to this day one of the real prominent first major reversals of a conviction because of prosecutorial misconduct, withholding evidence, and so forth, that really came to my attention was the Ted Stevens, former governor of Alaska. I've mentioned it before. And a absolute scathing opinion about the conduct of the prosecutors, who were never even named. Never even named. We don't even know who they are. So they don't even have that minor personal consequence of experiencing a little bit of shame as a result of their bad behavior. They're not even called out for it. It's just attributed to the nebulous the state. So I can absolutely see an argument that if If we're going to actually disincentivize this, there need to be actual consequences for it. Dismissal is a serious remedy. You know, it's a hard sanction, and I don't dispute that. Because that would mean that there are cases where somebody who did something horrible is going to go free. They're going to remain, you know, a risk to the community, that type of thing. That's the risk that you have with dismissal being a remedy. That's a big burden for society as a whole to be bearing for bad prosecutors. So I don't know about that one. I think that one is hard. But just as an absolute bare minimum, should prosecutors be having some more personal consequences for misconduct? Absolutely. Yes, absolutely. It should be career ending to do that type of thing. It should be career ending. And yet that's not what happens. What happens is they often end up getting promoted. It's a dirty, dirty game and a dirty, dirty system. Far, 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 far too often. Good question, and a very, very hard one for me to answer. Law Kong Express. The state has declared, sorry, we have gremlins. Yeah, our bad, our bad. I can't wait for them to give that explanation to the jury. That's why this video is so sketch. It has nothing to do with us. It's just the gremlins. It's just the gremlins that live in the CPD. Joseph Bradley, how is the state showing sallyport video that supposedly occurred prior to the dates in question to show no video tampering? Did they forget their 30-day override excuse? Exactly. Exactly. How did they go back and get the video from January of 2022 to show no problem? See, because they couldn't anticipate that the defense was making any of this argument, right? That's why they couldn't produce it in the first place, because they're not mind readers. They couldn't expect that the defense was going to want it or that it was going to be useful. They want it every which way, don't they? Yeah, I think you're right. I think they did forget about the 30-day override excuse, because where is this video? Where did they get this from? How did this not get overwritten back in February or early March of 2022? Even if there was a full download of all of the Canton sallyport video with the SUV or the time frame or whatever, they went and got it all. Why would they have gotten some random January 1st video? No, it didn't happen. Yeah, the provenance of this also would be very interesting, wouldn't it? So many questions that didn't get answered and that are hinting at the explanations we've been given so far may not be entirely truthful. Lucifer. I have a feeling if Karen never showed Jen her cracked taillight, this case never would have been brought. Thanks, Andrea. I selfishly don't want you to go to the trial so I can watch it here with you and listen to your giggles. I am not planning to go to Massachusetts for the trial. I will plan on watching it here. I've already been away for quite a while, and I am anticipating going to Boise for the Koberger trial. That's going to be a pretty long time away. Now, granted, Boise is not as far away from home for me as Massachusetts is, but it is like a 5-hour drive. It's pretty long. And so, you know, I may come back on the weekend from time to time, but it's not like I'm going to do that as a regular commute or anything. So I kind of owe my husband a little bit of time at home. And that's part of the luxury, you know, when we do have these trials that are streamed, that we have the camera feed. Being able to do that from home is quite an advantage. So I don't want to take up one of the courthouse seats from somebody who would get more benefit out of being present than I think I necessarily would. Sure, it would be cool to see the vibe and get a sense of the interactions and the jury, you know, all that type of thing. But I just don't feel like it's critical in this case for me to, for me to do that. So I'll be watching from home. You're more than welcome to hang out and watch with me. But yeah, it is such a good point. That is such a good point. I don't know. I do wonder. I wonder about, I'll tell you guys a little bit about what's been kind of circling in my mind as I've been thinking about this and the whole time frame. One of the things that has sort of stuck with me is why did they create a tumbler cannon? Why did they build that glass cannon? That just seems like a lot of effort and a lot of expense to go through to test like one single possible idea that may or may not have anything to do with the mechanism of how all of this went down. Their theory was, well, maybe John threw the glass at the SUV and broke the taillight. It seems like an awful lot of trouble to go through to assert a hypothesis that nobody else is asserting, right? So I have wondered if there is reason for them to think that maybe that happened a little bit more than just, well, there was a glass, bottom of a glass found, because we don't know if it matched the waterfall. Even the FBI never went and apparently, checked the glasses at the waterfall to see if it was the same pattern, same manufacturer, that type of thing. We know the glass on the bumper, the glass sprinkles on the bumper didn't match the glass that they found at the scene. So, the forensic case for that wasn't particularly strong. So why would we be hypothesizing that? Well, I've had a theory. It's just a theory. Not even a theory, it's a hypothesis. That, let's say that did happen. That did happen. Who are the people that would know that happened? Well, Karen would know. Karen would certainly know that happened, I would think. I mean, you could counter argue if she's real drunk, she's all intoxicated, the Commonwealth saying she had 12 drinks. Well, sorry, I watched with my own eyes. She didn't have 12 drinks and she really didn't seem that drunk. And like everybody testified, the Commonwealth's own witnesses testified, she really didn't seem that drunk. We saw her driving. Doesn't seem to be a problem for me. So I'm going to have a hard time with this idea that she's just so out of it that she wouldn't have noticed, somebody maybe throwing a glass and hitting her taillight. Like you're going to hear that. You might even feel that. I don't know. So Karen would know, but who else might know? Well, number one, people looking out the window, they might know. They might know that happened. Who else might know? Well, another hypothetical, if maybe Karen had mentioned this to David Yannetti in those text messages that, of course, Trooper Proctor didn't look at, didn't scroll through. We have a whole issue with the timing of the security of the phone, right? And when they got into it and what they learned and when they learned it and how, when they got the search warrant, all that. Yeah, we had a timetable problem with that too. So those are a couple different ways that folks inside 34 Fairview could have known if that happened, that it happened. But I think the easiest answer is just because they saw it out the window, maybe heard it. And so it would have already been on their radar as a possible, possible cover story. Some piece of information that they might be able to use to their advantage to pin the blame on Karen Reed and to set up the crime scene in a way to make it look like there was a motor vehicle collision or something like that. So, if that were the case, then I think that would be another reason. You know, it's just she was in the wrong place at the wrong time. You know, too much of an opportunity for folks. If they are, you know, going to save themselves at all costs, then you know, they got limited options to be able to do that. You know, possibility would have been trying to blame Lucky Lachlan. You know, the snow plow got him, something like that. But the other opportunity was Karen. And so that might have been on the radar from the very beginning. And then, yeah, maybe as soon as Jen sees there's a piece missing from the taillight, we can really work with this. Yeah, then it goes forward. I can see that possibility for sure. DC10, Andrea, you are a genius. You have an all-star chat with Truth and Transparency and Aussie Insider. Love what you guys do. Well, thank you so much. We do have an awesome chat here. We have the best chat. I know everybody always says that, but they're wrong. I have the best chat. And I've said before how awesome they are and what great resources we have, and they're so clever, and like look at the cool usernames and stuff. We have a great chat. John Beattybot, Hank's trial 2 strategy is to pound table, distract, and delay. Yeah, it's gonna be a different vibe for sure. I don't think he's gonna bore us to death like Mr. Lally did, but I don't know that that's necessarily going to be a better strategy, because I don't know that paying a lot of attention to Mr. Brennan and what he's doing and how he's doing it is really going to be advantageous for the Commonwealth, because it's just not that persuasive. When you make the gaslighting and everything that overt and that explicit, absolutely no inference, no evidence, nothing, like we're seeing it with our own eyes, you know? It's going to be a very, very different mood, the second trial. So it will be interesting to see how that plays out. Bird, I missed the hearing, but I appreciate being able to catch some of the recap. This judge is infuriating. Thank you. It really is. It's so frustrating because it seems like such a minimal ask for the judge to just have some freaking decorum and some even-handedness with how you treat the parties. And so to be so oblivious, to be so unable to see what so many of the rest of us are clearly able to see, which is this grudge against Mr. Jackson that kind of seeps through to the defense team as a whole, and precipitates her treating them differently, calling them on the carpet for things that the Commonwealth does repeatedly over and over and over and over again and never even gets a raised eyebrow. We can all see it. And so that's why it's so infuriating, is because you're just like, how can you be so blind? How can you have such little insight that you don't even see it? It's very obvious to the rest of us. Greg, I hope this court will hold the Commonwealth to the same standard it holds the defense. This was said twice today. I kind of took that as the attorneys telling the judge they're not being treated fairly and they're tired of it. Yeah, I think they're making their record. They're making their point. I would have loved to have seen Bev's face when they made these comments. Because I'll tell you, there's been one time in my career that I remember making this comment, this same comment. I would just ask that the state be given the same treatment as the defense. And boy, the judge doesn't like it when you say stuff like that, when you call the judge out. And you know, Bev didn't say anything, so there won't be anything in the transcript that would help with a record, you know, that shows, oh, she reacted to that, or she, you know, she took offense at that or something like that. It's not in the record. In my case, you know, the judge gave me a very stern look and then verbally said something to the effect of, I always do that, Ms. Burkhart, something like that. So, you know, the judges don't like it. You know you're at risk of blowback when you make a statement like that. So they have to be feeling that it's necessary. It's worth the risk at this point. They need to start calling it out. They need to start making it evident. They need to start making their record. And possibly that's because we're less than a month from trial now. And it'd be good if she got it in her mind before we're in front of the jury that you need to be paying attention to treating these parties equally. Because if the jury gets the idea that you're putting your finger on the scale, that you favor one of these sides over the other, yeah, that's not good. That's not good. And maybe it's a little bit of a warning shot too, that they will make a record when they see it. Marcelo, kind of disappointed that Bev did not say Brady doesn't apply in Massachusetts, Mr. Jackson. That's not how we do it in here. She worries so much about Karen Reed's rights, but doesn't protect them. Yeah, well, because the concern trolling is just a cover, right? She's concerned about her defense and her the effectiveness and preparation and all that type of thing. But it's not. Of course, she's not worried about that. It's just that that's the only avenue that she has to be able to criticize the defense and try to make something material out of it. If she actually cared about Karen's rights, she would have done something a long time ago about these problems with the discovery. This is not new. This is going on well before the first trial. This is going on well before the first trial. And that's why it's still happening, because there have never been consequences for it. She just lets him get away with it, and there's no blowback, nothing. So, no, I think when it comes to what her concerns are, the actions speak far, far louder than the words. And the fact that she hasn't done anything to protect Karen's rights. We didn't hear anything about the metadata motion today, did we? That was supposed to be the other thing on the docket, the motion to reconsider the disclosure of the metadata. I kind of got the impression from what Ms. Little said yesterday and what was in the affidavit that the Commonwealth has already destroyed it by going and doing the whole drag and drop the files onto a disk to then produce to the defense at 11:30 on Monday night. That would have destroyed the metadata. It's kind of the impression that I got from the affidavit. So not clear to me if that motion is not being pursued because now it's moot. There's nothing that can be done. What's done is done and it's over. And now the metadata is gone and there's no way to be able to get it back. Not clear if that's it or if it just fell off the radar. She didn't address it. I don't know. I'm kind of concerned about that. Because, yeah, I think a judge who is concerned about the rights of the defense, the rights of the defendant, would be a little bit more concerned about stuff like that. Why is the burden on the defense to establish the forensic process that's necessary to preserve the metadata? The Commonwealth has their own experts in that. Their own experts should know what's necessary to preserve the metadata. And so they should know how to produce the evidence in a way that preserves it. So I certainly hope this isn't the end of it. I hope this isn't the end of what we hear of it, because if they just destroyed the metadata this last weekend by doing a drag and drop, there needs to be a spoliation instruction at a minimum. At a minimum. Because they would know. They would know. If that knowledge is within the realm of what the defense experts, digital experts can know, then it's within the realm of what the Commonwealth's experts should know. So they should know how to be able to produce it in a way that preserves its integrity. And if they didn't do that, you should be able to infer that that is because they didn't want you to know. Melissa Dotson, Andrea quote of the day. Why don't you just spread his cheeks a little wider? I mean, it was just getting a little slurpy, wasn't it? Yeah, that it's kind of gross, honestly. For a guy that's on the text chain about searching for the nudes. Yeah, I really didn't need all that. Phil, the Gilbert villain Biggs. Andrea, Higgins used CPD burner phone 2 a.m. to call who? Well, that's interesting. If he's on a different phone and it's not his phone. Yeah, that is the $1 million question, though. Who was the phone call to? Have we gone through, like Brian Alberts' records, to see if there's unknown calls coming in there? I don't have the call logs, memorized off the top of my head, certainly. Who else would he be calling? Who could he be calling at 1:30 in the morning? Why is he calling anybody at 1:30 in the morning? He's a guy that lives alone, right? He just went home to drink some more and go to sleep on the couch. So who does he have to check in with at 1:30 in the morning on Friday night while he's over there moving his cars? I don't know. Could be somebody, but I don't know, because he omitted that part of his story. Yeah, we would definitely all like to keep pulling on that thread. Aussie Insider, Andrea, is trial 1.0 record not treated as a whole with everything being preserved on the record now? I'm not sure I totally understand this question, but I mean, yes, there is a record of trial 1.0, and the record is going to consist of the transcript, the total transcript, yes, including the sidebars and everything that was done outside of, the presence of the jury, the presence of the public, etc. That's all part of the record. The exhibits are all part of the record. Typically anything that was marked, whether or not it was introduced, remains a part of the record, because that can be, necessary for appellate processes. All the pleadings and filings and everything that was made as part of the case. That's the total record of trial 1.0. So yes, it should be all preserved. It should be all on record. Anything that came up during that process is part of the record now. Hopefully that is answering what you were looking for. Proctor's hard time in the big house. You've made me realize I've forgotten. I thought the Cannon was to show 24 miles per hour in reverse into a body and wouldn't break the taillight. Now I realize, no, it was the throwing of the tumbler. It was to see if that was consistent with a possible mechanism for the damage to the taillight. And it did. I mean, even at the time, it was like, it's weird. It was especially weird because, the defense calls ARCA, so the defense just elicited everything that ARCA did. Even this particular piece of evidence that isn't consistent with the defense theory of the case, right? They're not putting on evidence that happened. But they, so it's kind of out of the blue. And I remember thinking that's strange. I wonder, I can see how hypothetically, you might come up with that as an explanation, but it just seems like an awful lot of effort to go through and an awful lot of expense to go through to disprove, one small possibility. If that wasn't suggested to you, if you didn't have a reason to think maybe somebody was going to say that happened, maybe somebody is on record somewhere suggesting that happened. Gotta wonder. Well, guys, that was exciting. That was exciting. Didn't get the answers that we were looking for, did we? And Even more reason to think there's a reason why. There's a reason why we didn't get those answers. There's a reason why they are not spelling out the who, what, when, where, how details of all of the video. They're not doing that for a reason. It's going to be bad. That's why if it was helpful to the Commonwealth, they could just absolutely spell it all out and say on this date, this person went to this person and they downloaded it and they downloaded it to this and then they did this with it. Here's how the normal system works. Here's how those actions interacted with what the system normally does. They could just explain all that. And so the fact that they won't do that, and we keep getting all of this passive, and we keep getting all these explanations that don't actually answer the questions, it's telling. It's telling. And the whole problem with the 30-day overwrite, yeah, that's just not a good explanation, because it sure is seeming like that's not something that's always been the case. That's new. And so if that's new, when did that happen and who did it and whose call was it? Gotta wonder. Phil, the Gilbert villain Biggs, every reason to think Albert and Proctor had access to burners too, as police detectives communicate with CIs. Yeah, very good point. Very good point. Communication with the confidential informants. I mean, Higgins even talked about that being within the scope of his work, that he works with confidential informants. That was supposed to be his explanation for why he had to get rid of his phone, right? Because 6 months earlier, somebody had gotten it, you know? So then suddenly there was an urgency to get rid of it right before there's a preservation order. Really didn't land with me from a persuasive standpoint. But yeah, we know that's within the scope of his work. And so it would be kind of normal for you to use a work phone, not your personal phone, to be interacting with your CIs. Pretty unusual to be trading like personal information with your CIs. Cops are usually pretty big on the OPSEC, you know? The times are different now, but I mean, even back in the day with the yellow pages and stuff like that, they'd be unlisted, their numbers would be unlisted, their addresses wouldn't be listed. Yeah, they could have had access to burners. Greg, wasn't it ARCA's testimony that they were given the evidence and just broadly told to figure out what happened? No, they were given specific questions that they were asked to answer. Now, was one of those, I don't recall specifically what the questions were, but my general recollection was the damage to John O'Keefe, to his body, was that consistent with the motor vehicle collision, and was the damage to Karen's taillight consistent with the pedestrian collision theory? So I don't think they were specifically asked, in the scope of their retainer, to figure out if John O'Keefe could have thrown the glass. So I don't know where that necessarily came from. I don't know. But it was definitely more specific than just here's the evidence, figure out what happened. It was using their expertise, the biomechanical and the accident reconstruction, to sort out very specifically, were these consistent with the explanation of a motor vehicle collision between Karen's SUV and John O'Keefe's body. And they, of course, concluded that they were not. So, don't know where that theory came in, and why it came in, and why. I would like to know. Oh boy, especially if we're gonna, continuing to just think down the road if the Commonwealth's going to get into, the ARCA isn't unbiased because Karen Reed paid them $23,000 after the fact for their testimony, and so then we open the door to the details of what ARCA, charged and was paid for and what. I would just love if we got the opportunity to know how much of their bill could be attributed to that Cannon, because it really seems like a not cheap thing to me. That seems not cheap at all. To build the thing and to test it, the time that it takes, the materials, all that, that does not seem inexpensive to me. And so it's a lot. It's a lot to go through just because of maybe it happened like this. I don't know. I will even grant that the government doesn't have the same type of budget considerations a lot of the times that somebody like Karen, a private person, is going to have, because the government, they just rely on the tax and the budget and however much politicians feel like giving them to do their jobs. But even in that context, it's usually not unlimited. It's usually not just a blank check to go out and spend whatever you want whenever you want. Like, there has to be a justification for it. The Cannon, that seems like a lot. So again, it's just a hypothesis I've had and something that's been kind of going around in my mind that I have wondered about. Did folks see John? Is that what happened? Did John throw the car, throw the glass? If John threw the glass at the car, I mean, it explains a lot of things to me. It explains why, they had a fight. Seems pretty clear they had a fight before Karen left, and they didn't resolve that because she's leaving the angry voice messages for him and stuff. So corroborates that there's a fight. But it might that also explain how things could accelerate so quickly in the house? If the tension that is kind of spilled over and leads to a fight, fight with John at the house, which is, what he looks like in terms of his clothes and his body and so forth. That's certainly the defense theory. Higgins does seem like one of the likely opponents, adversaries for that fight. So, could that explain how things could precipitate so quickly? They see John throwing it out the window. Is Higgins still soft for Karen? Is he still trying to, I said soft, not hard. He's still, trying to get something romantic going. He's still got those feelings for her, something like that. Might that piss him off? John's got the girl and he's still so disrespectful to her, and that's why she should leave you, and that's why she kissed me, or something like that. Could be as easy or as quick as that. It does explain the possibility to me how some of this stuff unfolded and why it did. So yeah, I don't know, but it's just a thing that's out there. Well, so we'll be back on April the 18th for sure. We will be definitely back to watch those hearings on the motions in limine. In the meantime, I've already mentioned some of the stuff I'm working on getting caught up on. A lot of Koberger stuff to still go through. Still want to finish watching that juror interview that Turtle Boy did. Motions in limine are going to be coming in, might have the chance, might sit down and make a video about that. So that's what I'd say look forward to from me in the next couple of weeks till we get the hearing. I said April 18th, but I meant March, right? It's March 18th and 19th that we're yeah, I said April because I think she said April, but I think it should be March. It's about 2 weeks from now. And so we've got the hearings on the motions in limine for that. In the meantime, I'm going to do my best to get some stuff out. I don't know if it's going to be live or if it'll be pre-recorded. Pre-recorded is probably a little bit more likely, but I don't don't know, guys. It kind of just depends on how things unfold. So anyway, definitely appreciate all of you joining me today. Appreciate everybody in the chat, all of the comments, all of the keeping us on track. You know, I love how whenever something happens, like the stream goes down, I can have faith that the chat's going to figure it out. If it's up somewhere else, you're going to help me find it. Just love having that type of support and that type of community here. So we'll see if someday we get answers to any of these questions. I can't wait to see what the defense has by the time we get to trial. I sure do hope. I sure do hope they're able to pin some of this down. What about that 30-day overwrite? Oof. Yeah, that seems like an issue. All right, guys. Thank you so much for joining me. I will look forward to seeing you again the next time, if not sooner than at the latest, for the March 18th hearing, when we'll be back for the motions in limine. And more Alessi, more Mr. Alessi, Daubert-Lanigan motion on that neurosurgeon. So can't wait to see how that goes, guys. In the meantime, please take care of yourselves. It's starting to be spring. I'm looking outside right here. We've got some sun. It's beautiful out there. Take some time to enjoy it. The days are getting longer. The light's coming back. You know, there's always another summer. Always another summer. And we may not always be here to see it when it comes. So we got to enjoy it when we have it. So do take time to take care of yourselves, guys, and make sure that you're getting what you need to take care of yourselves and look out for yourselves. So with that, thank you again. Appreciate all of you, and I'll see you next time.